Right, okay. Let's kick off. First of all, welcome to the SRA in Birmingham. Thank you very much indeed for coming along today. I'm Julie Brannan, Director of Education and Training, and what we're going to do today is talk through some of the changes to the Code of Conduct and the Handbook, the introduction of the new standards and regulations, so that you understand some of the thinking behind them, and I hope that will help you contextualise the new provisions when you're teaching them to students. I'm going to kick off by a brief sort of introduction going around the room so everybody has an opportunity to say who everybody is. I am not going to do very much talking at all today because I'm delighted that we've got experts from our team who have been involved in the development of the rules who'll be able to talk those through to you. So perhaps if we kick off by introducing ourselves and then we'll go around the room and hear from you. Do you want to kick off, Amanda?
I'm Amanda Fox. I work on the policy team and I've been working on the handbook review for the last 4.5 years.
And I'm Carol Westrop. I'm head of legal policy in the General Counsel team, so part of the team that has actually done the drafting of the new standards and regulations, and I'm a solicitor, so it's me.
Good morning. I think I've spoken to nearly everybody. I'm Pat Mulverhill. I'm responsible here at the SRA for quality assurance of the current provisions, so particularly the LPC and the QLTS for this morning.
Oh, I think we have somebody later on. Come in, we've only just started. And before I hand over to you for introductions around the room, let me just remind everybody that, as you can see, the camera is in the corner because we're live streaming this, so that it can go out to colleagues who weren't able to make today, and also it will be recorded so it will be available on our website for people who wish to refer to the session later on in the year. So we hope that provides a helpful resource. What it does mean is that we are mic'd up for questions, so the speakers, if you have questions and so on, the speakers will repeat the questions into the microphone so that it can be recorded and people outside the room can hear. So you'll have to just bear with us as we repeat your questions before we answer them. Great, okay, so let's kick off round the room.
So I'm Mark Piano and I'm representing QLTS School.
Lorna Lewis, Cardiff University.
Sorry, can you just give us a moment in between each person? Thank you.
Lorna Lewis, Cardiff University.
Natalie Gibson, University of Huddersfield.
And Lucy Floyd from City University.
Shall we go on to the table at the back?
Yep, I'm Gareth Bramley from University of Sheffield.
Amy Russian from BB.
Claire Sumner, De Montfort University. Linda Challerton, University of Central Lancashire.
And should we come onto the table in the middle then?
I'm Paul Fletcher from Liverpool John Moores University.
Chris Jorgensen from Barbury.
Becky Hopkinson from Leeds Beckett University.
Jason Giorgio from Birmingham City University.
And then back into the table at the back.
I'm Jackie Kempton from the University of York. I'm Carol Sherry from the University of West London.
Ian Holden from Jane Wood also from Nottingham Trent University.
John Clifford from Pearson College.
I'm Bally Sandhu. I work for the SRA in the policy team, so I'm a policy officer and work very closely with Pat.
I'm Rob Wilkes from the University of South Wales.
Excellent. Well, thank you very much indeed. I'll hand over to colleagues in a moment. Just to say that the ladies and gents are out there on the in the main foyer. Lunch will be served about 12:30, and we do not have any fire drills planned for today. That's our Wednesday routine. So if the alarm sounds, it's for real and we will have to evacuate the building, but hopefully that won't happen. So having said all of that, I will hand over then to Carol, who's going to kick off.
Yes, hello, welcome everyone. Just make sure I'm going the right way on the slides. Yeah. So I'm just going to talk to you for about half an hour on the background to the introduction of our new standards and regulations, hopefully to provide some helpful context to you when you're looking at how this material relates to what you're teaching your students. Hopefully you will know that our go live date is the 25th of November 2019, and obviously we in the SRA are doing a lot of planning and preparation to make sure that all of our stakeholders are ready for that date, and we are ready internally as well. So the rationale for the new standards and regulations, this is the culmination of a lot of engagement that we've done with members of the profession, the public, training providers such as yourself over the last, as Amanda said, 4.5 years. Just to be clear, that the aim is to keep the current very high standards. You'll probably be aware of the dicta in Bolton that we rely a lot on the SRA, that solicitors should be trusted to the ends of the earth. So keeping high professional standards is obviously very important to us in the SRA. And our key objective, as we've distilled through our policy statements, is twofold: to provide proportionate protection to the consumers of legal services and uphold the administration of justice and the rule of law. And you will be aware probably that under the Legal Services Act, we, the SRA, have a number of regulatory objectives that we need to meet and have regard to in our work, including ensuring competition, a diverse legal profession, that the client's interests are protected, and so on. So those underpin our thinking behind the new standards and regulations. We have done a lot of drafting of the rules to try to address some of the concerns in the rules. They're lengthy. The current handbook is very long. It's quite complex to navigate your way through, and it's costly for us to keep up to date and to apply. So I think we're on our 19th or 20th edition. Clearly some of those changes that we've made over those last 19 or so iterations were because of changes that we've incepted, but some are because of developments in the law that we've had to reflect in the detail of our current handbook. So the aim between our new standards and regulations is to keep them shorter, simpler and clearer, much less process orientated. So we've included only rules that we think are justifiable and taken out a lot of process. And they're organised much more coherently in 18 sets of rules. Now I know for you only a limited number of those rules are going to be of particular interest, and Amanda and Jatinda will talk about those in detail, but it's obviously quite important, I think, that you understand the broader context of the standards and regulations as a package. One thing to mention in our drafting approach is that in terms of stripping out unnecessary detail, we've taken out all references to primary legislation. I think the only two areas that impinges upon both the accounts rules and the codes is in relation to the removal of the obligation on reporting accountants to notify us promptly if there is theft or serious risk to client monies, which is in section 34(9) of the Solicitors Act 1974. And there's also a reference in the outcomes to the requirements under LASPO in terms of referral fees. That reference has come out. There is a reference to it in the introduction of the codes, and I think there's going to be detailed guidance in relation to that. So there are two instances where we've taken out the key concepts of what's in legislation. It's more relevant in things like the authorisation rules, where we have taken out detail, for example, to detail from the Legal Services Act. That won't be as relevant to you, but you should just simply be aware that's part of our drafting approach. We've tried to use much more active, simpler language. We've also refocused guidance, and I'll talk to you a bit more about the role of guidance shortly. So just moving on then to the actual sort of overview of what the standards and regulations look like. As I said, we're going to concentrate today on the RISE principles and the codes of conduct and the simplified accounts rules. but we also have authorisation rules, and you will probably have read, if you followed our consultations, that a lot of what we're trying to deliver is a greater practising flexibility for solicitors, and that's done through our authorisation rules. So in terms of the rules themselves, I appreciate this is probably too much detail for you, but simply because you will have the slides available, important that you can actually see the breadth of the suite of the rules, including overseas practice, authorisation of individuals and firms, assessment of character and suitability in terms of entry to the profession, and I think Amanda's going to touch on that very, very briefly. Role, register and publication. We are setting up a new digital register, which will include details of all practising solicitors, registered European lawyers and registered foreign lawyers, as well as firms and other key individuals that we have a regulatory reach over, such as employees who we have prevented from practising in law firms that we regulate. So our new digital register, which will be available from the 25th of November, will include a lot of useful information in relation to the entities and individuals we regulate. And then we have rules around indemnity insurance, our compensation fund, and so on. So the benefits and opportunities, a lot of these are for the profession around the more flexibility about how firms run their business. But just to echo that the high professional standards that we require will be fed through all the ways in which solicitors can now practice, including being bound by the Code of Conduct for Individuals. Easier to use and navigate, easier for the public and for entrance to the profession. This is probably an area where you will be interested in. We think that they are easier for people who are being trained on them to understand the logic and the flow of the rules. And for someone like myself who's been involved in a lot of the changes, looking at the existing handbook seems to me quite difficult to find your way around, and the new rules we hope should be much simpler and clearer so that people understand the very high standards that we require as solicitors, but without getting lost in unnecessary prescription and detail. So that's the aim, the benefit and the opportunities of the new rules. The role of guidance and support, you will have noticed if you've looked at the new rules, I'm sure you have, that we've taken out the guidance notes from the rules. We obviously have to be careful. Guidance, it's not rules by the back door. That's clearly not our intention. But there is a need to refocus and recalibrate really how we use guidance to support the profession to understand their obligations. A lot of the guidance in the existing handbook is already out of date. Part of the rationale for the new rules was to make sure that we could future-proof the rules, that they are more flexible in terms of the drafting. So, but we do understand that there's clearly a role for guidance, particularly in grey areas, in complex areas, or difficult areas to understand for the profession, or also to reflect societal and technological changes. So, for example, you may have seen one of our toolkits on the use of social media and what we think is acceptable for solicitors to use in terms of Twitter and other ways of social media. So we've set out a guidance note about use of social media, which will help solicitors in the profession really navigate these sort of new developments, which we intend to be useful. So part of our role is to review and to streamline all of our existing guidance, and to have a range of guidance that is sort of more flexible. So we're thinking about case studies, decision trees, different ways of presenting guidance that will hopefully be more engaging for the profession and will help them to understand the issues more clearly. Now, Amanda and Jatinda will point you when they go through their sessions at key pieces of guidance that will be of particular relevance to you, we think. We've issued a swathes of guidance already on accounts rules and the authorisation suite of changes, and there'll be further guidance coming out between now and November. But I say we'll try to point you in the direction of the key pieces that we think you will be interested in. So the thing I want to talk to you about is the work that we're also doing on our website, because obviously part of making our standards known, to make sure people understand the standards and comply with them, is making them available. So we have a new beta website that is in development. I don't know if any of you have looked at it yet. That's on our website, and it's a way in which we're going to, rather than our existing website, which has a lot of information on there, but we're conscious that sometimes it's difficult to find a piece of guidance or the thing that you're looking for. So as part of the rollout of the standards and regulations, we're also looking to improve the way in which we communicate these issues to you and to the profession. So our beta website is a key part of that, and you'll see the link on the slides. And we'll encourage you to use it as a test and to provide us with your feedback, particularly you as a cohort that is looking at it through the prism of your students and how you might use it in terms of your teaching aids. So we think that would be great if you could do that for us. The aim is that it will be a much more search-led experience. It can be personalised to the individual. You'd appreciate that we regulate 10,500 law firms, from very small sole practitioners to very large multinational firms. And sometimes finding that piece of guidance or the set of rules or the thing that is most relevant to you can be quite tricky. So we're intending to authorise a personalised experience. I think of it a bit like the Netflix, where it makes recommendations from you based on your previous watching experiences, and you can search in terms of areas that you're interested in. It's going to be mobile friendly, so you can use it on your tablets or devices, and it'll be easier just to scan read and actually find the key thing that you're looking for by use of these expandable boxes. So you click on it and it'll give you more text, but you can see the headline quite quickly. In terms of how the standards and regulations are going to be positioned, so I've got an example here. This is the assessment of character suitability rules, but you will have the rules themselves, and on the right-hand side, you will have guidance, so key pieces of guidance that attach to those rules. You'll have the glossary terms. Obviously, we define a lot of our terms in quite a detailed glossary. It's got much shorter as a result of the redrafting, but clearly we do that to make things concise. And you can also note issues next to the website. So if you want to annotate issues with case law or other developments that is particularly relevant, then you can do that. You can bookmark, print, and highlight. So in terms of a tool for both perhaps you and your students, that will be quite a useful resource going forward. So I said the beta site is up and running now. But it will be launched on the 25th of November, which will have, hopefully by that stage, a full suite of what we think is relevant guidance and other issues. Ideally, links to forms, a forthcoming consultation, and so on. So that will be kind of your one-stop shop for issues around the new standards and regulations. So we hope that will be helpful. As I say, please do have a look at that. Now and feedback any comments that you have during this piloting stage. I just want to talk to you briefly about the enforcement strategy. Again, I don't know if any of you have seen this document. It's very much part of what we currently do within the SRA to assess the seriousness of matters that come through our front door. We get thousands of reports and complaints from members of the public, from the judiciary, from other solicitors, which obviously we welcome because we are very much an intelligence and information-led organisation. And so that we can assess the risks that firms pose, we actually want to make sure that we get the information in and that we assess it and obviously we record it. The enforcement strategy, which has actually been around since 2011, sets out really our appetite for enforcement and what we think is serious. And this builds upon some work that we did in 2015 called A Question of Trust, where we went out to the profession, we went out to a lot of students as well as to members of the public saying, what do you think is serious? What should we, the SRA, care about? And we did a significant piece of engagement, and that threw up a lot of very interesting information. For example, the public are very concerned about confidentiality. They regard that duty as being sacrosanct, and any breaches of it they regard should be sanctioned very heavily. The profession, perhaps a bit more pragmatic in terms of the demands of a busy practice, taking files home, reading material on the trains and so on. They were much less pragmatic and less concerned about breaches. So we took all of that information and learning, and we've refreshed and updated our enforcement strategy. The aim of our enforcement, we have a set of rules, I should say, called the Regulatory and Disciplinary Proceeding Rules, which sets out in detail our enforcement powers and sanctions that we have to fine and discipline solicitors and employees of law firms we regulate. But the enforcement strategy really sets out that the purpose of our enforcement, we're not a punitive regime. It's all about protection of the public, controlling or limiting the risk of harm. That might involve removing someone from practice through our right to ask the Solicitors Disciplinary Tribunal to strike off or suspend someone if they've been found guilty of serious misconduct. But really we're there to protect the public, to send a signal to those we regulate about the very high standards that we expect them to maintain high standards of competence. So our enforcement strategy says, for example, we're not going to take action against a single isolated mistake, but we would be concerned about a pattern of incompetence that puts clients' matters at risk. And ultimately around upholding public confidence in the provision of legal services. That's very key for us, that people are confident in legal services. So that underpins our enforcement approach. The learning that we took from A Question of Trust and from our engagement work has led us really to set our stall about what we think is serious. Some things that are going to be very clear-cut. We'll always be concerned about an allegation of dishonesty, about a criminal conviction, because clearly those go to clients' interest, public trust and confidence. But there'll be a lot of areas where it's much more grey, it's more difficult to assess what's serious, and the enforcement strategy tries to articulate that. So, for example, there's a range of aggravating and mitigating factors. Our new enforcement strategy that was published in February of this year makes it clear, for example, that seniority is something that we take into account. We expect a greater degree of knowledge and insight for someone who's been practicing for a number of years than we do for a new entrant. So role and experience is something we will take into account. We accept there's contextual mitigation, so someone new will work in a firm where they may be subject to stress and difficult working environments, and those are things that we will take into account, so that, as you may have seen from recent case law, a stressful situation cannot excuse significant dishonesty. And again, that comes back to the test that we need to make sure solicitors can be trusted to the ends of the earth. Harm and impact, deliberate or reckless behaviour is obviously something that we're going to take much more seriously than a single negligence act, or if someone has looked at the rules, looked at the criteria, looked at the evidence and actually made a reasoned judgment that, for example, it was appropriate to act in a potential area of breach of confidentiality or conflict, because they've taken the factors and they've actually applied their mind to it and come to a reasoned decision. So harm and impact, the vulnerability of clients. Clearly, we are very concerned to protect the consumers of legal services, particularly those who are vulnerable. Regulatory history and patterns of behaviour. Clearly, people can make an isolated mistake or do something wrong. When it happens again, is something that we're clearly going to be more concerned about. We've done a lot of work around our interest in someone's private life. The principles, as Amanda will tell you, apply to people whether they're practicing or not in their private life. And obviously there are some interesting conversations we've had about how interested we should be about people's actions in their private life. So, for example, possession of drugs, drink driving, those sorts of issues. And we have enforcement toolkits which helps explain our approach and why we're interested in these kinds of issues. Insight and remediation, people understanding what they've done, putting matters right, the obvious things that you would expect us to take into account if looking at what's the appropriate action we need to take on the back of a complaint that we've received. So that's I think the enforcement strategy in a nutshell. I want to talk to you a little bit something a bit more practical in relation to you, and this is in relation to your ability to reproduce the standards in terms of your preparation for course materials and so on over the forthcoming months. We have received a number of requests for reproduction of standards and regulations. Our current copyright notice basically says you can use excerpts of our website content provided it's fair, it's accurate, and that it's used for academic research, the general copyright disclaimers. But it doesn't deal with what you do if you want to reproduce a whole section of our rules, the codes, the glossary, the authorisation rules, the accounts rules, and so on. So we've received a few requests for this over the last a few months, understandably, as we get ready for the 25th of November. So we are in the course of developing some quite short terms of use. Essentially, the message is you can reproduce. We want to know that you're going to use the content. So what we are devising is a simple form that you simply tell us who you are, what you want to reproduce and where. And there'll be some fairly standard and hopefully quite straightforward terms of use. So for example, requiring you to keep it accurate and up to date. Obviously, if it's online content, that's reasonably straightforward. If it's published, then obviously as soon as reasonably practical. To reference the SRA's content, that we're giving you a license to reproduce it, be royalty free for use, but with some limitations of that way. So that's the present position. I say that is in flight at the moment, and we'll update our website with that when we've finalised the terms of use. If any of you do want to reproduce our codes or our accounts rules, and now if you email me, and we'll provide the details, or our digital comms team, we can facilitate that by giving you Word or PDF versions for you to use, and just point you in the right direction of the terms of use to make sure you're happy with them. But we don't think there'll be anything controversial in them, and hopefully you'll find that helpful in terms of getting the materials ready for your students when you do start training on the new standards and regulations. So that is what I wanted to say. Does anyone have any questions on any of that before I hand over to Amanda?
Is there any likelihood that's going to be a guidance is going to be published as is the original guidance we've got at the moment for students? Is it going to be a similar publication with the new code, or is it going to be reliant? Because we or give our students at the moment a textbook based on the regulations and the solicitors' account rules. We've been in touch with the publishers, and they said that there may be a new book coming out after November or at some time with these new codes. With the account rules.
So we're not intending the SRA to publish a textbook, but there may well be either the Law Society or another publisher may decide that's what they want to do. I mean, I think in terms of the length of the rules, I mean, it's if you're printing out 500 pages, but actually the entire set of all of the rules, I think, is 50 or 60 pages. And whether or not that would be of interest to you, I don't know. But certainly in terms of the material we're giving you now, I think it's 7 pages for the accounts rules and so on. And I'm hoping that the beta site will be a very valuable resource so that people don't have to, perhaps, I mean, we all like paper and us lawyers love paper. For particularly students who are much more used to dealing with matters online, it may well be that they are happy just to rely on the beta website. But I can try and find out the answer to that question, and if I have any information, I'll let you know. Sorry, this gentleman here.
Just linked to that question, really. I asked the Law Society when they're planning to publish their version of the Code of Conduct, because we do use that textbook currently. But they've come back to me to say they can't publish that textbook until they know they have the finalised version of Code of Conduct, and they're unsure as to when that will be. So, is the current Code of Conduct the final version, or will it be updated, amended shortly?
Yeah, it's a very good question. The question was, is what's on our website, either on the beta site, or we've got a PDF on the SRA's website of the current rules. Is that the final version? No, it's not. We have the version that we will give to you in terms of the codes has included in it, because we thought it would be sensible and easier for you, our recent reporting concerns amendments. So we had an additional consultation to expand the circumstances in which we expect people to tell us of issues. So that is in the version that you have. It's not yet on the SRA's website, and there is, although, as I said, we did 4.5 years of engagement, we went out to consultation. Inevitably, now that the deadline has been published, people's minds are concentrated on looking at the details of the rules. So we are finding a few small tweaks and snags that we need to make. We hope that will be with you shortly, and perhaps as part of our communications with you, we can let you know when the final version is on our website, if that would be helpful. Does that answer your question? Sort of.
My concern is mainly linked to us being able to prepare in terms of our teaching for the next academic year. So at this point it's difficult to prepare materials for teaching because we haven't got the final version of the Code of Conduct. So you're saying that's going to happen soon, but how soon it is soon? So will it be ready by September?
So the version that we're giving you today is the almost final version. There may be a couple of tweaks to some of the glossary terms potentially, but for the codes and the accounts rules, you can regard those as final, subject to very small tweaks. So I think you will probably have sufficient for what you need. Conscious, for example, that dare I say the word Brexit, that there may be some potential Brexit changes, but those are going to be to the authorisation rules, potentially if we do reach a no-deal position on the 31st of October, and that won't at the moment affect any of the codes or the council rules. So the version that we will give you will be a more up-to-date version than is on our website, and it's something that we're working through.
But I think just to the hand over there in a moment, but just to add what Carol was saying, I think the purpose of teaching on the LPC in particular, the code and the principles are, if there are any tweaks to be made, they're not going to affect the position substantively in terms of what you are teaching to your students, so that you will be able to rely on what is there at the moment if you're going to be teaching this from September.
Yes. I think very minor tweaks. So we're talking about a very small potential change. But in terms of the content, that's what you need to be teaching against.
So I've got a couple of questions. In terms of the guidance, will that replace what's currently in the indicative behaviours in the current code? And to what extent can we rely on those indicative behaviours if we're kind of trying to anticipate the final version, including the guidance?
The indicative behaviours have gone, as you will have seen from the drafts. Oh, sorry. The question was: will the indicative behaviours go? Will it be replicated in guidance? And how could we rely on the existing indicative behaviours when perhaps planning at this stage? Because I can see why you would want to see the guidance that will help perhaps contextualise what it is that you're teaching, and certainly the aim is that we would get all the guidance products certainly before November, and a lot of it will be well in advance of then. I think, as Julie rightly sort of presaged, there isn't, and perhaps I should have made this clear, and it's certainly come through Jatinda and Amanda's, although the rules look quite different, in many ways they're unchanged. We've taken out the detail, we've taken out the prescription, but the core responsibilities remain unchanged. We haven't, our statutory obligations in the Legal Services Act, the Solicitors Act, have not changed throughout this. So in terms of our core obligations, our core ethical expectations of solicitors hasn't changed. I think what has probably changed is a great appreciation that you know, the solicitors that we regulate, that you train, are highly skilled professionals, and we expect them to exercise their own judgment on issues. But we accept that there are issues where, either because, as I said, technological or societal developments, things are new or things are just quite difficult. So the guidance will be aimed at those areas. Does anyone have any further questions? And we'll have plenty of time for questions, I think, in Amanda's session or over lunch, where we'll be staying. So if you haven't, then I will pass you over to Amanda.
Okay. Thank you. Just before I sort of leap into the principles and the codes of conduct, I just wanted to slightly contextualise why we thought it was quite important to mention the enforcement strategy to you. And it's because the enforcement strategy completely underpins the principles and the codes of conduct. If you look in the introductions to the principles and the codes, that makes it very clear. It says it is underpinned by our enforcement strategy. So when you're thinking about training, when you're looking at the course material, I think it's quite important to bear that in mind. They are a suite of documents. Our enforcement strategy, although we've had it since 2011, it's been a bit of just how we do it. So as Carol was describing, to actually be looking at the harms, the impacts, the mitigations, the aggravations, it actually helps people to interpret the codes, I think.
The thing about the enforcement strategy is that it sets out what the SRA is interested in. It sets out the SRA's approach. If there has been a breach of the rules, it explains the circumstances in which the SRA will be more or less worried about what has happened. I don't think that you need to require your students to memorise the enforcement strategy, but I think it's very important that they understand that it is there. And that as they enter the profession, they understand what its purpose is and their responsibilities in relation to it. I think it's actually very helpful guidance for a solicitor, for any practicing solicitor, in terms of setting out the SRA, their regulator's approach to matters which are of concern to the regulator.
Absolutely. Okay, so what we propose to do before lunch is to take you on a quick run through the principles and the two codes of conduct. As Carol's already alluded, and I think it's important to say this up front, they look different, but fundamentally not a huge amount has changed. So in terms of what you'll be teaching, there's nothing really new in there. So in the packs that we gave you, we've provided you with a copy of the new principles. Has everybody had a chance to have a look at those on the beta site, or is there anybody who hasn't seen them before? No? Okay. So the most obvious thing you will see from the principles is that they're now shorter. So we've gone from 10 principles, which we have at the moment, down to 7 principles. So what the principles are, as you'll know, they're the fundamental ethical tenets of behaviour that we expect of everybody that we regulate. They apply not just to solicitors, but also to firms that we regulate, managers of those firms, employees of those firms. What is slightly different with the new principles is their application. So at the moment, the principles that we have in the current handbook, they apply to solicitors both in and out of practice, but not all of them apply both in and out of practice, and they don't apply to everybody. So that's a fundamental policy approach change. They will now apply, insofar as context permits, to everybody that we regulate, both in and out of practice. So this is coming back to what Carol was touching on. So it's about your private life. And again, this comes back to the enforcement strategy. We may be more or less interested, but we are always interested. Okay, so in terms of the principles that have come out, can anybody tell me which ones those are from the current principles?
The ones that are more to do with practice management.
Absolutely right. So because we want them to be ethical tenants' behaviour, because they really encapsulate what we expect of solicitors, there were ones in there which don't. So they're very important, and we do take them seriously. So protecting client money and assets, that's currently a principle. It's no longer a principle because it's not really well, I suppose that one is arguably an ethical behaviour, but it's less. So it's more about business controls. The other ones that have come out are the ones about cooperating with your regulator and the ombudsman. Again, that's very important. We take it very seriously, but again, it would never apply sort of out of practice. There is one anomaly in the new principles. I don't know if anybody wants to have a guess at what that one is in terms of what I've just said. So, okay, right. So it's the new principle 7. So it's act in the best interests of each client. Arguably, you're not ever going to have, that's not going to apply outside of practice. And that's why we say that they apply in and out of practice insofar as context permits. But because we think it's so fundamentally important, we wanted to keep it up there in that very, very short list of behaviours that set out our expectations so clearly. Another thing I just wanted to touch on is our new principle, standalone principle, that you act with honesty. So when we went out to consultation on this way back in 2016, we actually consulted on a principle that said you act with honesty and integrity. We were quite clear in our own minds internally that those things were separate, or you could plead them separately before the SDT. That didn't really seem to be the external understanding of it, and there was some quite unhelpful case law for a while, wasn't there, Carol? Do you know? Can you remember which one it was?
I can't remember what it was, but the issue was that one I can't remember whether it was SDT or a High Court case basically said they're synonymous.
Yeah, and we'd been very clear and said they're not. Yeah, so we've separated them out in the new principles.
And I should say have had further case law that has actually upheld the fact they are a different standard, they're different tests.
Yeah, and there's a very, very helpful test now. It's IVV Genting, which has set that out and put it beyond doubt for the time being, once and for all. Okay, so as we said, there's no major changes. There's no entirely new principles. Just to summarise back again, they apply in and out of practice to everyone. One of the things that people have said to us is that we've lost the principles. We haven't. Just go on in a bit more to say where they've actually gone. As I said, there's a new principle to act with honesty. And as Carol also alluded, we were going to tell you as we go through about guidance that we're producing, new bits of guidance. As Carol said, it's we're producing new guidance around the handbook, and one of the key pieces is guidance on integrity, and that will be published, I think, this Thursday, and we will provide that to you as part of the post session. Okay. So yeah, moving on to talk about the codes of conduct. So everybody has seen the new codes of conduct? Yeah, again, okay, great. So the code of conduct for individuals, that covers solicitors, RELs, while we still have RELs, and registered foreign lawyers. And it applies wherever they work. So this reflects the new practicing requirements. As Carol touched on very briefly, we're freeing up solicitors to work in a whole range of different ways. So at the moment, they can only practice in firms that we regulate. And we took a policy decision way back in 15-16 to actually change that and free them up to actually practice in firms that we don't regulate, and also potentially to practice on their own account. But what's important to note about the code is that code goes with them wherever. So wherever they're practicing and however they're practicing, they're personally accountable for the code of conduct for individuals. And again, it's about standards of behaviour, as you'll know, having looked at the code, it's about the standards we expect. Again, it's much shorter than the current code. One of the reasons that we split the code that we've got at the moment wasn't just around the practicing requirements, it's also because the single code we have at the moment is actually quite confusing. So to unpick as to what is your individual responsibility, what is the firm responsibility. And part of that is because the current code uses you interchangeably to cover both of those. The current code is also not massively helpful to in-house solicitors. It just dumps them on, as you know, at the end of each chapter. Again, makes it feel a bit like an afterthought. And actually, a lot of in-house solicitors didn't even realise that the code applied to them at all, because they were not working in a firm that we regulate, which is a reasonable belief to have. So the code of conduct for firms, that sets out more of the standards and business controls, and that only applies to firms that we regulate and the solicitors that work in them. So you asked about indicative behaviours. They have gone. The reason that we decided to take them away was because they were quite widely misinterpreted as actually being rules because they were in the rule book. They were never meant to be rules. That was our attempt with the 2011 handbook to try and be helpful and help people to interpret the rules. But their understanding about what they were and what their status was quite mixed. So we made a decision quite early on that we would remove them, but we haven't just removed them. We've actually considered very carefully, literally on a IB by IB basis, as to whether we thought they were helpful. If we thought they were helpful, do we think we still need them? So some of them have actually now been escalated up. So some of the previous indicative behaviours you'll now actually see reflected in the wording of some of the standards in the codes. Some of them we have moved into guidance. So the new guidance that's coming out around the code. Some of them have gone. Some of them we have formalised into case studies as part of the guidance. But actually, we're pretty confident that we've kept everything we needed from the indicative behaviours. So again, I think it comes back to what you were saying, is can you still rely on them? Yes, I think so. I do think you can, because they will be reflected somewhere. Sorry, Julie, you're looking at me in a very sceptical way.
So I was just wondering about that. I mean, the current indicative, I think what Amanda, well, I don't want to put words in your mouth,
tell me what
Amanda, but I think what Amanda is saying, I think, is that the content of the indicative behaviours is reflected in the new standards and regulations where it is appropriate. So there are some cases where they have, we felt that they weren't helpful. In those cases, they've been removed. But where we felt they were helpful, they have been incorporated either into case studies or into guidance, or in one or two cases, they are now hard rules.
They are now hard rules, yeah, because one of the problems with the indicative behaviours was that it was the language as well of them. Acting in this way may show that you've met a standard. Well, our standards are, we think they're set at the right level, so either you've met them or you haven't, and either you've not met them in a minor or technical way or as a one-off or as a mistake, in which case we probably won't take any enforcement action against the solicitor, or you've deliberately flouted them or gone way over the line, in which case we will. Okay, so I feel almost as though I'm now going to tell you things that you already know. So as you know, the current code's 11 chapters long. The new code is 11 rules long. Were there any particular rules that you wanted to sort of go through in the codes as part of this session? I better get my code.
What about confidentiality and disclosure?
Okay.
Something that there's not anything explicit about confidentiality and writing disclosure that there needs to be.
Okay, well, probably can we pick that one up? Confidentiality and disclosure, can we pick that up at sort of the end of the session? So I think in terms of actually picking up any detailed questions, it was just really more, is there any sort of general theme in there or anything that's occurred to anybody going through them?
Can I ask you about 8.1 in the code for solicitors in terms of you identify who you are asking for in relation to any matter? So I'm thinking about the money laundering regulations require solicitors to identify their clients in certain situations.
Okay, that's another good one to pick up at the end then. So pick up on that one if that's okay. Okay. So on that basis, though, I think probably the most helpful thing to cover, given that you've all clearly been through them, is to pick up on the new reporting concerns requirements. So in the rules that you've got on your tables, you have the new reporting concern rules at 7.7 to 7.9 in the personal code, that rule 3 in the code for firms. So as Carol said, we went out to an additional consultation on reporting concerns last year. It was partly because of discussions we were having externally, and it became quite clear to us that people's understanding of when to actually report things to us was really mixed. Some people, some firms, some compliance officers would report to us quite early on in an investigation of their own, and they would sort of be quite upfront with us. Others would only come to us once they'd actually concluded an investigation. So we thought it would be helpful to provide some further clarification on that. So we went out on a very narrow consultation on three new rules. The first one is about when you should report to us. So what's quite key to just sort of stress at this is it's when firms or individuals reasonably believe that there might be a problem. So we're not expecting them to have concluded an investigation. We don't want to know if they've got, if it's a mere suspicion, we don't want to know about mere suspicions. If it's a reasonable belief that they're sufficiently concerned that they're doing something about it themselves, then we would encourage them to report to us at that point. It is an individual responsibility. That's why it's in the individual code as well as the code of conduct for firms. So it's a responsibility on a solicitor to tell us when they reasonably believe. We also ask them to involve us where we might be able to help with our wider regulatory powers. So there are some times that we could actually do investigations that would be more difficult for them to do, particularly around sexual harassment cases where it's, one person's word against another. And the third part of that rule, which we also added, was some protection for whistleblowers. So it makes it very, very clear that firms, individuals, managers, cohorts are not to subject anybody to detrimental treatment because they have either made a report to us or are considering making a report to us. And so reading across between the two firms, the responsibility of an individual solicitor will generally be discharged if they report to their compliance officer. However, we have become aware of some cases where clearly the compliance officer is not going to report it on. So the reporting obligation then on the individual solicitor is to report directly to us. I think that's quite a important distinction to make. So, but only when you know, for whatever reason, the compliance officer is not going to report on to us. Okay. So yeah, just to go back quickly then over what I've said so far. There are fewer principles. Honesty is now a principle. There are 2 codes. There is some overlap between the code. You'll see when you're looking at both codes together, I know clearly students don't need to know that much about the firm code at the point where you're teaching them. Probably helpful to make them aware of the rules relating to managers and SRA firms and compliance officers, because that's where there's quite a lot of, that's where the codes tend to interlink. And also with the parts of the code where it's about actually delivering services to the public, there's the firm code actually references a lot of the individual code. Okay, so the indicative behaviours have gone. Within the codes as well, there are a couple of things that are completely new, that haven't been there before. One of the new examples is like don't waste the court's time. So you won't have seen that before in the current code of conduct because it actually isn't there. So those were things where, because of the way that we've been regulating over the last sort of 5 years, what we were seeing coming in on the sort of enforcement side, actually we thought that we probably did need 1 or 2 extra rules. And that one in particular, I think, has been around. We get in reports occasionally from the judiciary, as Carol said, about, for example, immigration solicitors taking a whole raft of cases that are totally without merit to court. So it's a high-level rule that would catch that kind of thing from an enforcement perspective.
If I may ask a question, because I come from a criminal background, what am I to do? And this is a conflict we have more or less every day. You have a client with a hopeless bail application, but insists on an application for bail. If I make that application, am I wasting the court's time?
So I think it comes back to what Carol was saying. So, question, do I have to repeat the question? Yeah. The question about how to interpret that rule about not wasting the court's time. Again, it comes back to the solicitor's judgment. You will, as a solicitor, be making a judgment call, and you may advise your client, that it is hopeless, but equally you're balancing that with your duty to act in your client's best interest. Precisely that, yeah. So as with everything in the new handbook, it's everything is looked at on a case-specific basis. So there are no, they're not prescriptive rules. It's use your judgment and be able to back up the decision you've made. And if you can do that as an individual, then we will generally be happy that you as a solicitor, as a competent professional, have made a judgment based on the evidence, and we will accept that.
But just, if I can just pick up on Amanda's point, I think she's absolutely right to draw this to everybody's attention, because it's something which is new and which is perhaps a slightly different way of looking at things. There have been issues, particularly as you mentioned, in the context of immigration cases, and the courts will now declare cases to have no realistic prospect of success. And there is a point when, if a solicitor brings a case with no realistic prospect of success, that may be an abuse. It's wasting the court's time, and it is an abuse. And therefore, we are interested when those steps are taken for reasons which are not proper reasons. So it might be part of game playing, it might be in order to earn fees, it might be for all sorts of that would be an improper purpose if you're bringing a case in order to earn fees when you know that it has no realistic prospect of success. And the courts will now declare cases to be like that, and they will look at particular patterns of behaviour where they might have repeated cases brought like that, and that is clearly a regulatory matter for us. So that is something I think which is important for people to know, that they do need to exercise their judgments around that. And of course, ultimately, if you have a client who's insisting on that, then the way out is for you to say, I'm unable to act. And that is the matter of professional judgment that solicitors will need to make.
Can I just say that's really unhelpful? As a criminal practitioner, I am as well. He works part-time. It's going to be a nightmare training criminal practitioners on the LPC and trainees and in practice. And it's going to be a nightmare navigating that as to whether you've got a prosecutor saying to you, well, you do realise this is without merit and I'm going to report you. I think description in some areas is really needed, and I think that the difficulty with this is trying to teach students to pass an assessment is going to be a nightmare, because you're telling us it's all based on there's going to be no right or wrong answer.
So there are right and wrong answers, but they are not. It's not about following prescriptive rules around those right or wrong answers. There are right or wrong answers, and people. I guess the change in approach is for people to learn to understand how the principles on which they reach right or wrong conclusions. Where we think that there is additional clarification required or additional guidance, then that is set out in the guidance. And I think, that we can give some reassurance in the sense that some of these harder areas, there will be guidance which is available. But for example, it should not be surprising to anybody the proposition that if a solicitor decides to conduct a case in which is hopeless, where their client will lose in order to earn fees, that is a matter of professional misconduct.
And that speaks for itself, and that would be breaching integrity.
Indeed, it would indeed, yes.
Rather than you can't make a bail application because it lacks prospects, and something like that in the guide or within the guidance that says a client exercising their right to make a bail application would not be in breach of this, would get rid of all that, and that prescription in some circumstances is required.
Yeah, I mean, part of obviously the learning from this and your feedback will be just for us to sense check whether on areas where you feel from the way in which you approach matters, there are areas where some degree of guidance or a case study or a toolkit would be a helpful resource to help you decide which side of the line it should be on. I mean, there's obviously, my understanding is there's no intention of saying you can't bring claims that that you think may be quite difficult to win. That's not the intention. Yes. But I think Julie's right. There's something around bringing a case which is for improper reasons, where you're doing so to bolster up your fees. You have a repeated conduct of doing this, and we became alerted of this because we were getting repeated complaints by the judiciary of applications for asylum that were completely meritorious. And one of the question of trust issues that we raised was, what do people think? Do they, what do people feel that this is? Because you're right, there's a balance between acting in a client's best interest and fiercely, putting forward their interests, and that's a proper part of the rule of law. To actually, or the converse, which is wasting courts' time bringing meritorious, where we know the courts are under so much pressure. So there are some difficult judgments to be made. I mean, I feel as a solicitor that solicitors often have to make in all walks of life, or whatever area of practice you do, difficult judgments around difficult concepts. That's part of what we're trained to do. But I think we are saying that if there is a particular piece of area where it is causing solicitors difficult in practice to understand where the line is, then that's the kind of thing that we would address through some form of guidance, a toolkit or something. So perhaps our action is to look out and see what we've got or what we're planning on this area, and whether we think there's a gap.
But I think the point that I would just add to that is that we are not doing anybody any favours by being aware that there is a professional conduct problem here and not surfacing it through the rules. And it's also an area where we, I think guidance may be required, and we shall see whether further guidance is required. And in part, this is. We move forward gently, and we see and adjust in the light of experience. But it's quite hard often to have a prescriptive rule around those sorts of things. Actually, in the end, it does come down to the exercise of judgment, and that, as Carol said, sometimes a difficult exercise of judgment. And and that's when then you have a look at the enforcement strategy, and the enforcement strategy also sets out guidance about the circumstances in which we would think that something was a serious breach of the rule, where, for example, an application was brought for improper purposes, or where it's something where there might have been a technical breach, but we can see that somebody applied their rules, that applied their mind genuinely with a view to trying to do the right thing. They may have got it wrong, but they were trying to do the right thing, and I think there's a world of difference between that and somebody bringing a case for improper purposes.
I accept all that, but in order to teach young people who are
Yes.
moving into the profession,
Yes.
they need context and they need rules because some of them don't make sense.
So I think the important thing in terms of the teaching is the sort of approach that we just identified, and I think that it is going to be a more challenging thing for you, but I think that's really, I mean, in a sense we've got to the heart of, I think, what we wanted to get over through this session, that the teaching approach is very much around, there are these hard judgments that people have to make. It is about you really genuinely, as a professional and as a professional solicitor, exercising your judgment with integrity and honesty to try to reach the right decision, and that is the learning in terms of the approach for students that we would expect them to take into their professional life.
The difficulty for us though is we're going to be standing there saying we believe this wouldn't be right and we believe this would be right, because the students are going to look to us to say, well, what would we do in that situation, and we've got the benefit of, I mean, I still teach some of the 1999 rules because they were prescriptive. So for argument's sake, those rules say that a client can admit an offence for expediency as long as you tell them not to. So a client can lie for expediency. Now that rule says that they can do that, whereas the new rules don't permit a client. Yeah. So the point I'm making is, and I appreciate, forgive me, I will stop, is that your guidance will be key for us to put it into context.
I'm sure that's right, and again, just to repeat, I think students will do that. They will put you on the spot and say, well, what's the right answer, what's the wrong answer? And there may be cases where actually it's a more useful learning exercise to have a debate around that and to surface the sorts of considerations that people might wish to take into account in reaching their judgment, rather than saying, well, in all circumstances this is going to be the right thing to do, in all circumstances that's going to be the right thing to do, because I'm not sure that will necessarily be correct.
I don't believe anyone teaches in that way. Yeah. That's not what the LPC is about, but they have to leave with day one competencies to know that, am I able to act, am I not able to act, and us saying to them, well, you can always withdraw with the best will, doesn't particularly help them, but yes.
Yeah.
So I think what Julie and Carol were both picking up on is really important. We know there are grey areas, and it does link in very much to our enforcement work and as to what we're more or less likely to take account of. So if you look on our website, when we've published our updated enforcement strategy in February, we also published some topic guides that we've been using internally in our investigation and supervision function. Again, to actually help our people to interpret, but we thought they were quite helpful, so we made those publicly available. So there's some guidance on there on criminal convictions, on behaviour on social media. There's some really good guidance on Principle 1 on there, because we have the same internally. We have the same struggle as to what's proportionate, what's transparent, what's reasonable. Are we being a reasonable regulator? How can we be consistent in our decision making and consistent in our decision making from any point in the organisation? So I would really recommend that anybody who hasn't looked at the topic guides does have a look at them. And it sounds as though it probably is an area where I think we probably need to add that particular rule to our list for some further topic guidance.
Can I just a little bit more, because I think again, both of us are spoken from a criminal practitioner background, where predominantly our work is legally aided. There isn't the natural break on a client who's funding their own case in that scenario. So you may have a client, if they're funding their own case, you tell them there's very little prospects of success, they make a judgment call. The criminal client doesn't have that. They're locked up on legal aid. There's going to be more pressure to make those applications because you're talking about somebody's liberty. So I think you do need to consider some guidance for possibly the legally aided.
Yes, that's very fair comment. I think we are taking away an action from today to actually think about a topic guide around that very topic. Okay, so the only... Oh, did I lose my... Yes, I did lose my character and suitability. So I just wanted to talk very briefly about this. I know it's not actually something, it's not something that you teach, but I think it's something that it is very helpful for students to be aware of. And this is a change to the way that we assess character and suitability. So at the moment, with the 2011 handbook, we have an SRA suitability test. And at the moment, we apply that at the point where people go into a training contract and also, again, at the point of admission. There are quite a number of issues with the current suitability test. It's really inflexible. It actually drives us down lines that we don't necessarily want to go to. It's very black and white. So when we're looking at the whole of the handbook, and it is a set of rules in there, we're looking again at our whole approach. So the first thing that we decided was that we would remove the requirement for trainees to be assessed at the point that they go into a training contract. And this is linked again to opening up routes to qualification. Really the only point that we're interested in whether or not they are of suitable character and suitability is at the point of admission. So we'll now just assess everybody, so whatever route you come through, whether it's through a training contract, whether it's in due course through any of the SQE routes, whether it's through the apprenticeship route, we'll just assess everybody at the point of assessment.
And
so
again, just to butt in again, sorry, Amanda,
It's
you
all right.
tell me to shut up, but there was an anomaly. So apprentices did not have to be assessed when they began their apprenticeship. Trainees did have to be assessed at the beginning of their training contract. The purpose of the character and suitability test is to check that somebody is suitable to be admitted as a solicitor. There are all sorts of people who work in legal services in a law firm without having a character and suitability test. So that was the sort of thinking about having it as a point of admission requirement rather than the beginning of the training contract requirement, bringing everything into line and not having a carve out or a special rule that applied to trainees but it didn't apply to other people.
Thank you, Julie. Yes, no, that's very helpful. So we made that decision to remove, and then we had a look at the test itself. Our starting point really was, as I said, that our test at the moment is enormously inflexible, and kind of pretty much means that if you've ever had a criminal conviction, it's driving us as an organisation towards actually saying, well, no, you can't be of sufficient character and suitability. We're all aware that people in their teens and in their early 20s may do something, they do silly things. Some of them get caught doing silly things. That doesn't mean that they won't go on to actually to become very good members of society, and that we shouldn't be barring them from coming in. So we freed up the character and suitability test to make it a lot more flexible. And again, this thing that we keep coming back to, it comes back to everybody is now looked individually on a case-by-case basis with the same kind of factors in the character and suitability test as we have in the enforcement strategy. So you'll be looking at the same sort of categories as Carol showed on her slide. So there's criminal behaviour, dishonesty is always going to be a bit of a no-no. One that we've kept on there, although we struggle sometimes to get evidence in of it, is still around plagiarism. So we take that very seriously. That's still in the character and suitability, is something we'll take into account. The challenge for us is that we quite often don't get to hear about those.
So again, the important message is that we are interested to hear of those sorts of issues if and when they arise in your organisations, and please do report them to us. We then will include that as part of the assessment of an individual when they come through at point of admission.
But again, the purpose of our enforcement is not to be punitive, but it is something that we want to take in mind.
It's really of relevance to us when we make decisions about admission.
Yeah.
Does that mean they've been removed from the LPC? Because you used to have suitable character to enrol in the LPC.
Oh, that went in, I think, 2014, when the 2014 training regulations.
Membership went, but I thought you still have to, if you had problems with suitability.
So they had an opportunity to make an early application, and the opportunity for an early application still
remains.
It remains.
So that was going to be my last point, actually. So So we thought long and hard and decided that for all sorts of reasons it made absolute sense to retain that facility. So our pre-admissions team will very happily assess and give a view. What they won't do, which is slightly different, up until now they would actually give a decision. It won't be a binding decision. So if you become aware of students who've got a potential problem, whatever it is, we'd really encourage you to refer them through for an early assessment if that's the right answer for them. We'll be able to provide them with some reassurance, and in the most serious cases it'll be quite obvious, I think, to them.
Yeah, I'd like to go back to the point linked to plagiarism, because it just struck me at my university, I mean I'm sure it's similar in all of your institutions, we have different levels of plagiarism. So we suspect plagiarism, we report them under the academic misconduct panel. We can then, if it's found to have happened, we can then penalise them. If we just have a suspicion, do we have to report them to yourselves, or do we have to have gone through our mitigation process and we found them to be guilty, we've suspended them or penalised them in some way? Is that when we report, or if they're removed from the course, do we report at that point? Just to clarify exactly when would it be appropriate to report?
I mean, I think this fits in with our reporting arrangements. So if you have if it's mere speculation, then we're not interested in hearing. If it's a finding, we certainly are. And if it's sufficient of a concern that you are taking steps in relation to it, so you might have initiated some sort of process, then again, that's something that we would be interested.
Absolutely would be interested in.
Yeah. And the point about this is that in the end, if there is a question of misconduct or something which is relevant to the to admission as a solicitor, then we need to be made aware of it in terms of making a regulatory decision about the extent to which that's something that we need to take into account. Yeah.
Oh. Yes, so I was going to say something about guidance as well, but we've touched on this at various points through this morning. In terms of guidance, we were very clear from a policy perspective that in shortening the handbook, we weren't sort of making rules by the back door by replicating everything into guidance. So we've been a bit more intelligent about that and produced guidance in a range of forms. As we've said before, it is very much around the grey areas. We touched on that when we were talking about the topic guides. We do remain open to producing guidance when people flag up to us that these are grey areas, that we're struggling with them. For you as education providers, it may be that, as you say, you've already flagged up one or two areas where you know that guidance would be helpful. Always, when we're thinking about whether or not we need guidance, that is the main thing that we're looking at. How does it help? So Carol also mentioned the guidance that's coming out around the handbook. So there is a tranche already done, which covers the accounts rules. There's some being published next week. Some of it's around conflict and confidentiality, but I don't think that particular guidance will be of particular interest to you, because it's more about practicing arrangements. The guidance on integrity will be really helpful. And then coming up towards November, we'll be doing more new guidance on some of the areas for the rules, particularly those areas where we've made changes. And on reporting concerns, we're working on a range of case studies at the moment.
So could you just clarify again, picking up mindful of your point about confidentiality, what's the timing for publication of guidance on conflict of interest and confidentiality?
So what we're looking at the moment is prioritising what needs to be ready for November, and the new guidance that relates to the codes of conduct is priority to be in place for the 25th of November.
Actually, it might be helpful. I haven't got anyone from my team who actually drafted the codes and the principles, but it probably, when Amanda's finished, it might be useful just to pick up your two specific points.
Yeah, I think so.
We'll if I don't know the answer, then I can go and find out, or make sure it's covered by the guidance that's in flight. I'm in charge of the reporting concerns guidance, for example. We're going to have a policy. The draft that someone's knocked up from me was already 20 pages long because we want to cover some trickier issues such as whistleblowing, LPP. Privilege is a huge complex issue. Disclosure in terms of the balancing the duty, your duty to disclose against your confidence is also a very tricky area. So perhaps when you finish that, we can go back to your 2 points and cover them in detail.
I think I finished.
Oh, you have? Oh, okay. Was there anything about the code for firms that we were going to say, or are we?
Pat thought probably the only thing really to cover on the code for firms was just to flag up the rules around managers and the compliance officers.
Yeah, I mean, I don't know if you've looked at the two codes. Obviously, you don't want to make your lives more difficult because your role on the LPC is to make sure that individual students understand the basics, and obviously they're only just starting off. So we want to make sure they understand the basics. A lot of what is in the code for firms actually mirrors what is in the code for individuals. So effectively there are mirror provisions. So it's not a completely separate or new or different set of rules. The only things that we think are of particular importance, and again, I would say not key to the core duties, are that they're aware of the role of managers in SRA authorised organisations, and that they're aware of the particular duties of compliance officers. So I think you probably would be covering that anyway, but those are the two sort of key things that you perhaps want to cover with them, and just so that they're aware of them.
Lucy, did you have a question? Yes, I just wanted to ask, in case you're able to give any more detail, you said there's some more guidance coming out next week.
This week, I hope. I hope, yes.
I'm sorry if I missed it, but can you able to say exactly what areas that's going to?
I know that one of the pieces is on integrity, and running through the recent case law, which Amanda alluded to, and the difference between dishonesty and integrity, and what integrity means in terms of the principles. I can't now recall what is due to be released this week, but I can find that out and we can cover that perhaps at the beginning of the session after lunch, if that would be helpful. I mean, I think in terms of just picking up the points on the detail, it might be worth just turning the pages on the versions you have and seeing if you've got any questions. Amanda can keep a note perhaps of any questions, and then if I can't find out the answer from the person who did the drafting in my team, who isn't in today, then we can either come back after lunch or we can email you out. And then we can come to questions afterwards. The first section, as you can see, is around maintaining trust and acting fairly. Then we've got dispute resolution and proceedings before courts, tribunals, inquiries, and obviously we've had a discussion about 2.6, and you don't waste the court's time, and what actually does that mean in practice in terms of that balance between your obligations to act in your client's best interest, but also to uphold the administration of justice and the rule of law. And it's probably true to say, I think, as Julie said, we in the SRA, the regulatory objectives have tensions in them. You know, to promote competition may be quite different in terms of our obligation to ensure access to justice. And sometimes we have to make quite difficult decisions about where we put our resources. I think it's the same in practice, but we picked up that specifically, that concerns that you have, that not wasting court time is perhaps a tricky area for you. We've got service and competence. So again, I think this is all very familiar. Acting in a competent way, keeping yourself up to date, making sure that you supervise properly. Then we've got the client money and assets. Again, this used to be the old principle. Amanda talked about that, safeguarding client money and assets, and you'll hear from Jatinder this afternoon that I think in all the detail in the accounts rules, I think sometimes people forgot what the accounts rules were for, and this is really just to reiterate the importance of keeping client money safe. You don't personally hold client money, so just to, I think we'll cover that this afternoon, but individually you can't hold client money. Our accounts rules are around firms. unless you are working in an organisation that's been prescribed by us. That's essentially the not-for-profit sector. So we will allow clients to, solicitors to hold client money in their own name if they work in the not-for-profit system, subject to compliance with some of the accounts rules obligations such as record keeping and so on. And then we've got the business requirements around referrals, introduction, separate businesses. Other business requirements. Conflicts, confidentiality and disclosure, always a difficult issue. Not a lot of significant change in terms of the actual rules. You will need to look at the glossary terms in relation to the conflicts and confidentiality provisions. So perhaps we can pick up your point, that your concern about the removal of the rule which says that you override your duty of confidentiality.
There's the rule about that confidentiality overrides disclosure. So there's nothing. I don't think there's anything specifically about when the duty of confidentiality and the duty of disclosure specifically conflict. It used to be directly in there in chapter 4. I don't think it's in there now specifically. Might be wrong.
No, I think you're right. I think it is that, because I think it's one of these areas in terms of future-proofing the law, future-proofing the rules. This is one area of law where obviously case law is important in terms of the court's views about where the boundaries between the two tensions lie. And it is a complex area because you do have these two sometimes competing obligations to disclose information, particularly to the police, for example, if you think a client is at risk of harm or a third party, and your really bedrock obligations of confidentiality. That will be addressed, I'm fairly sure, in the guidance that we are planning to issue on conflicts of confidentiality, and perhaps we can find out roughly when that's going to be in flight, so give you a little bit of a nudge in that direction. I would say nothing has changed in terms of, the law is the law. Case law is that hasn't changed. But the guidance sort of, I suppose, reminds people of the key principles, and that's what probably the bits that you found useful in the chapter in the 2011 handbook. So we can check that out. Then we've got cooperation, accountability. As Amanda said, that was an old principle, but obviously it's very key to us in terms of making sure people that do provide information to us, they do respond to our requests for information, our investigations and so on, and to other legal services regulators. Amanda's talked about the notification, very important to us. Risk-based regulator, we do a lot of proactive work in terms of horizon scanning, looking at risks to legal services regulation out there, but obviously we get a lot of information out and we have to risk assess that information. So getting the information is very important to us to build a picture of what action we need to take to protect the public. Client identification, complaints handling, again, that is again quite similar to the current information, information and publicity as well. Again, understanding your clients, understanding the regulatory protections, that is slightly driven to the new ways of working. So a solicitor can take their title solicitor and do non-reserved work outside of an SRA regulated firm. But it's important that the client can make informed choices when they do that about what protections they have. So nothing in there I think that's new, it's just shorter and hopefully pithier. Should we come to your point?
Yeah. So with respect to that individual responsibility to report to the SRA directly, if the compliance officer isn't going to do so, do you anticipate any guidance on that issue?
Yes, because I think that will be covered in the reporting concerns guidance that we will be producing. That is the 20-page, but needs to be, obviously, 20 pages is far too long. So yes, is there anything specific that you think isn't clear?
Well, I can just envision situations where there's a difficult situation in a firm when somebody has to report above the compliance officer, who tends to have more clout in the firm.
Yeah.
And I just wonder if there's going to be any guidance for these new committees to how to handle that in terms of the firm culture.
So you're thinking of someone junior who has a feeling that if they talk to the COP, who may be a partner, that actually won't be reported. and how can they do that in a way that is safe for them.
Correct.
Yeah. Yeah. Okay. We'll take that out.
One of the indicative behaviours on conflicts was where you're acting for lenders and borrowers in the same transaction, and that's gone now. But that's
yes, I would guess so. If that's an area that you think is again, this is not a piece of guidance I've been close to. That's why I'm slightly hedging my bets. I know it's being drafted by an expert, which my confidentiality experience is mainly due to when I was in practice many years ago. But yes, you think that the clarity about lender and borrower issues in terms of conflicts is something, then I can take that away and see whether that is going to be covered. I mean, again, you know, the difficulty which we have and you have is a lot of the detail of this will be in case law as well. So, you know, you need to keep it on track of, you know, the recent legal developments as well to understand the legal position. We can't replicate clearly in our rules what is sometimes a very complex legal position, and our guidance, you know, we try to, but you know, ultimately it's a question of practitioners have to keep it up to date with the legal developments that affect their areas of work, which I understand isn't necessarily a very helpful answer, but I think it's true. But in terms of lenders and borrowers, I will take a look and see what's been covered.
Well, actually, sorry, just on the topic of guidance overall.
Yes.
Perhaps a schedule of what guidance is going to be released and when it is going to be released will be useful for everybody. Yeah. I think we can provide that. We have the topics as part of our application to Legal Services Board for approval of the rules. We made an indication of some of those areas where we would provide guidance. Some has come out of events like this where people have said, actually, I think this is a grey area and I would benefit from it. Obviously, you're looking at this from your particular areas of expertise. So it will develop. I mean, we aren't clearly, when we go live in November, there will be further guidance that I'm sure will be necessary to bring into flight. But we also have to balance the fact that we are, you know, a reasonably small organisation, and we have to tailor our resources to what's going to be really helpful in a way that's going to be helpful. So we have to be quite smart about this. So we can't clearly promise you swathes of guidance. That wouldn't be right. It wouldn't be appropriate, bearing in mind our approach to the rule drafting. But there are things that we appreciate that people will need to help them navigate, and that's where we're putting our resource. So yeah, thank you for that.
In terms of assessing conduct on the LPC, as the content is very much more reduced, are we expecting students then are we going to assess students on the guidance as well as the rules? There's not as much to put into a standalone assessment as there has been previously.
Well, I'll defer to Julie on that because she's the expert in terms of the LPC course and to the role of. It's a very good question, and I think it's quite a difficult question.
So I think to the extent to which the guidance clarifies how the rules will work in practice, and just like, you know, you would have included the indicative behaviours in your teaching, then I think, you know, the relevant bits of the guidance I think would be helpful to include in your teaching. Pat, I don't know if you've got any thoughts about that.
I mean, I think the short answer is that because of the sort of phase that the LPC is in, we're not planning any changes in the sense of because obviously at the moment the length of the both the professional conduct and the solicitor's accounts rules assessment are in the LPC information pack, and it's not our plan at the moment to change that, simply because we don't want to start making changes to the LPC at this point, and we don't think that would be helpful or worthwhile. I think in reality, although the rules themselves have been cut down, and you don't have the bulk in there, nevertheless, the core duties are not really substantially changed at all. Just for myself, I have been through an assessment from an organisation, which that organisation kindly gave me their most recent professional conduct assessment. And so I went through that and had a look at what that covered and how that would change and what the differences would be in terms of the answers. And it seemed to me that the vast majority of those questions, obviously it also covers things like money laundering, and it also covers the financial conduct stuff, which we're not really talking about at all today. But I thought all of that was still relevant and still valid and still sensible things to be asking the students about. And although how you would put your model answers together will change in the light of the new rules, actually the assessment of itself would be equally valid in the current context. And obviously once you start to really engage with this and start to look at that, if you really feel, you know, we cannot get a long enough assessment out of this anymore, then you must come and tell us. But we think, certainly in the first year, we would like people to just do as they have been doing and see how that goes.
Just on that point, can I ask whether the written standards will be updated?
They will. But again, the written standards, particularly for professional conduct and particularly on the LPC, not quite the same for the QLTS. But for the LPC, they are actually, and again, probably most of you haven't looked at them recently, and I don't blame you at all. I wouldn't have looked at them when I was teaching it. But they're actually very high level, very general. They will be in that same format, so it will really just be the main headings from the new rules and the couple that we've referred to from the code for firms. So it will be similarly high level, and we're not expecting you to reinvent the wheel, really.
I think I can see what you mean about the assessment, because I've been through some of our recent assessments. Well, almost write an exam okay. What's more difficult is the teaching, because lots of teaching materials make reference, of course, to outcomes, but also to addictive behaviours. And I noticed looked at the CLP Legal Foundations manual for next year, and it makes quite a lot of reference. It says things like previous guidance has indicated that this might be appropriate or that might be appropriate or something else might be appropriate. And given that lots of us, I suspect, are going to be teaching this stuff in September, it seems to me that probably it makes sense to take a similar kind of approach in our teaching. Does that sound to you like the kind of thing you would expect?
I think we would prefer you not to be referring, as it were, as a category to the indicative behaviours, simply because that will be confusing to the students and will perhaps be giving them the wrong message. But certainly if there is, as Amanda said, some of the indicative behaviours have actually been translated into rules, and of course then that's great, you've got a nice rule to refer to. In some cases they will appear in guidance, and again I would say we're not worried about, in a sense, the students knowing where to necessarily reference that guidance. But if you've been able to say, give some context to them, which they're able to refer to, then we're happy with that. I think ideally avoiding the terminology indicative behaviour, because that's not the new world, is what we would be asking you to do.
But it's just that, as we said before, the law isn't going to change, the basis on which solicitors conduct themselves isn't changing. So it's really difficult to sort of see how we can make reference to all that previously existing material, which might well be helpful. If you're not keen for us to refer to it at all.
Well, it's fine if it ends up in the guidance, that'll be absolutely fine. And obviously some of it has become rules, but most of it will be somewhere, I think. Is that right?
Yeah, most of it will, and if it isn't, it's because we didn't think it was
right.
useful or helpful.
Yeah. So some of it's in case studies, I think, again, Amanda mentioned that.
But some of that will be coming a bit later.
Are you assessing, at City, you're assessing the new rules this coming year? Okay. So, you know, I think one of the things that you will have to be upfront with students about is that the new rules are not coming in until the 25th of November. So if you start the teaching of professional conduct in September, when as they arrive, as I expect you are going to do, that they will just have to, you know, bear with you as the guidance comes out and is clarified. You know, students will moan and groan about that, of course they will, but you know, that is another thing of being a solicitor, isn't it, that the law, you know, things change in mid-flight as you're working on a case or whatever it is, so it's just one of those things. And when will they be assessed then in February, March time? Yes. On that? Yeah, okay, so by the time they're assessed, then all the new guidance will be available. So, you know, if necessary, you can do a revision session just to bring them up to speed, I suppose. Yeah.
So, it's just a related point on that was about the exam and the marks, I suppose, and the rates taught. At Sheffield, we're doing the same at Sheffield, so in September we're teaching some of the rules. We used to give them a lot of credit and specific marks for quoting behaviours. To make up the 100 marks in the exam. And I can see the point about when the new guidance comes in to make the students aware of that. But a couple of points from there. I noticed what you were saying about the two sets of code of conduct. One thing we're thinking about, and wondering if it's overkill now, is we're going to perhaps say, well, this is where it appears in the code of conduct for solicitors, and here's where the provision appears in the code of conduct for firms, for example. So giving them credit either within professional conduct or within litigation. For example, in the exam, giving them marks for where they're able to show that understanding where the repetition is. And also where we're going to cover the previous marks for the indicative behaviour. So obviously, we're lawyers, we like referring to, as we keep saying, we like referring to specific provisions. I can see how that's not quite possible. And we can probably do it in terms of the understanding that we have before from the IBs as to factors. We will just give them credit for to put it in context and maybe insert marks there. But is it, for example, I suppose what I'm trying to say, number one, is it overkill to require students to get credit for referring to both code of conducts and getting extra marks? And also, where we had marks previously for IBs, is it better to say when we're drafting the exams, which we've done long before November actually, we don't set such a prescriptive mark scheme there, and we just kind of say, well, let's see what sensible comments they make about.
Well, I don't know. I mean, I guess we might want to have a bit of a debate about that. And I mean, a lot of those are matters of judgment. In terms of the code for firms and the code for individuals, I think that's probably up to you. Actually, you know, within, you know, as Pat was saying, the LPC handbook is quite high level. If you decide to go beyond that, there's nothing stopping you doing that. You know, I'm looking at Pat here. I'd be interested in your view, Pat. In terms of the credit for referring to the indicative behaviours, I think that is more risky because I think that's potentially out of date and I think as we were talking earlier, the approach to thinking things through and applying judgment is the sort of approach that we want. Pat, I don't know if you've got anything to add to that.
I mean, I think it might be helpful to get an idea of whether that is an approach that people, you as a group, as a whole, perhaps would welcome. I mean, this is very much my personal view. My personal view is that what we need the students to understand is the importance of the key principles. And my personal view is that unless we're asking them to explain the differences, simply being able to identify where the mirror provision appears of itself doesn't seem to me to add a huge amount of value. But I fully understand the difficulty you've got is that you perhaps feel that you're trying to stretch the current material you've got a little bit because we have done a job of really cutting this down for you, and so now you're trying to kind of, how can you, I mean, I don't mean this pejoratively at all, but you know, how can you pad out what you've already got to cover what it needs to do in the assessment? And I understand that. I don't know what the view of everybody else is, or whether you've perhaps thought that far ahead.
I think you're absolutely right. My concern is that I have a deadline to write an assessment and a resit by mid-September. And so the guidance or not all the guidance will be available. And what we usually are in our marking regime is I want a principle, I want an outcome, and I want an indicative behaviour. Sorry, I know it's very basic, but that's how we do it, and that's what we want, and that's how we tell our students to structure their answers. That's kind of out the window. And so if we are just asking them to think it through logically and what factors might be available for them to come to a conclusion, we're going to get very wide-ranging answers, and it's going to be very difficult to structure an assessment regime of marking criteria. I think that's what we're trying to say.
I think you are still going to hopefully be able to refer to a key principle.
Yes, absolutely. I see those two stages, and that's fine. It's that second stage, the grey, chatting about it, coming to a... And I know that's what you're after. I appreciate that. That's very difficult to assess.
One step further, to use 10 MCQs. It's going to be problematic as well, to try and get a right answer that's not a grey answer.
Yeah, we're half and half, so very
So I think there are these big questions that you're going to have to think about. Do you need a different form of assessment or not, or can you use that form of assessment? Can you identify bits of the rules? I mean, there will still be hard bits of the rules around conflict of interest and confidentiality, as there are at the moment. They'll still be hard-edged. I suspect you'll still be able to use those questions for part of your multiple choice questions. So I think there's all of that, and there will be the guidance that will come out, which may end up taking the place of the indicative behaviours in terms of your 3 tiers of categories that you identified before. I guess the thing for you, and I don't underestimate the difficulty of this, but the thing for you is in your decision about timing to recognise is that this is why we gave providers a little bit of flexibility in terms of the implementation and your assessment strategy this year in terms of whether you had decided to assess the new rules or the old rules. You will know your internal deadlines and your internal QA processes and how best to navigate your way through that in terms of your decision about whether to teach the new or the old.
So just picking up on your point, did you say your resit was in September?
Sorry, internal requirements ask me to write a first and second sit by middle September.
For the new
year,
based on the new rules. I see. Yeah. Interesting.
Just a very quick question. Is the correct way then to refer to these? Is this like rule 1.1, 1.2? Are they rules?
The paragraphs in the codes, they're paragraphs of the standards, and for the Sisters Accounts rules, they're rules. So for the codes, it's paragraphs of paragraph X of the code. I don't think you'd be assessing regulations, but if it was a regulation, and that's driven by our overarching statutory framework if we have to make regulations or rules. So it'll be rule 3.3 of the Sisters Accounts rules.
For the exam, do you envisage then, because the students are provided with a clean copy of the code, to be provided with the enforcement strategy as well?
I think that's a question for you. And as I say, I don't think we're expecting... The thing about, as Pat was saying, we will update the standards just to reflect the new language. The thing about doing that is that clearly back in the day there was no such thing as an enforcement strategy. So when I think the LPC handbook was originally written with the LPC outcomes, there wasn't such a thing as the enforcement strategy. So I would suggest that is for you. I think our expectation is that we don't expect the solicitors to memorise students to memorise the enforcement strategy. I think it's the approach of the enforcement strategy which is really important that they are aware of, so that they understand that there are a set of factors in there that the SRA uses in order to determine the seriousness of particular conduct, and therefore how we enforce against it. The action, the disciplinary action that we take against it. And I think actually just in terms of them understanding how to behave as a solicitor when they get into practice, I think that's very important.
Well, that consistency, not having it out, or,
Yeah. Yeah. Yeah.
I think one of the things that we've considered is obviously at this point what you're trying to do is save these people ever having to come across the doors of the SRA, not explain to them, you know, how they can commit a not so serious breach. So we want to make sure that we're kind of giving absolutely a straightforward message on their professional responsibilities. But the reason they do need to know about the enforcement strategy is simply because it is that underpinning document now, and it's referred to in the introduction to both the codes. So they need to know about it. And if you feel it would be helpful to talk a little bit more about that to them, then there'll be no objection to you doing that, I don't think. But obviously, you know, very much as that's why we're talking about it, rather than, I mean, I personally think it would be inappropriate to get too much involved in, you know, the gradations of bad behaviour, simply because ultimately that's a decision for the SRA. So.
But they need to know ultimately what the enforcement strategy
Yes,
is.
yeah.
Some, you know,
Yeah.
responsibility.
Just a quick question on part-time students, where we've got year one who've now studied the old rules and now going to year two, they'll be subjected to the new set of rules. Are there any suggestions how that could possibly be managed?
Have they already had their assessment?
In part, yes, but there's an accounts rules paper, part two. I'm not 100% certain because the conduct, some of these conduct is away and I'm here in this place.
Yeah.
So I'm not entirely sure. But this is one of the questions that he'd asked me to raise, whether there are any.
And following on from that, regardless of when your conduct assessment is, it pervades all the subjects, doesn't it? So all part-timers year one have answered questions in their previous assessments on the old rules.
So what I would suggest, and again, Pat, I stand to be corrected by you, but so for 2019 to 20, we have suggested, as you know, that providers can decide whether to assess under the old or the new. So for a part-time student who's part way through, I think that gives you some discretion to decide what's appropriate, and it may be, you know, through working out what they've already been assessed on and the timing of their continuing assessments this year. But where you decide to assess on the old, then we would expect them to be informed that what the new position is, but the assessment will be on the old. I guess then the next question is the part-time students who start this year and have got 2 years to go. And I can't remember, Pat, whether in our guidance we addressed the position of a part-time student starting this year. And again, I guess it depends on when they're going to have their professional conduct assessment. If it's after November, which it would be, they'd do their foundation course in September, and then they'd be assessed in Profcon when in about March time, something like that, would they? Yeah. Again, I don't know whether we specifically addressed this in the guidance, but for those students who will not be graduating for another 2 years, I think it's probably more important for them to learn the new and be assessed on the new rather than the old.
It was just the difficulties with the new and the year one students who now going
into year two. I think that they can take advantage of this year's flexible period. Does that sound sensible to you? It might be helpful for us to perhaps issue some clarification on that. I think it's quite a good point. And yes, you had to.
From a QLTS perspective, are you going to be updating the day one outcomes or the expectations for conduct? Obviously, it's primarily MCQ or exclusively MCQ from part one.
Yes, we are. Again, obviously, for those of you, most of you perhaps aren't familiar with the QLTS Day 1 outcomes, but those are a lot more detailed. And the reason for that is that obviously with the LPC, we've got LPC providers effectively translating what's in the outcomes into formal learning outcomes, whereas with the QLTS, you may have, and absolutely may have, individuals who need to be able to find out what they need to learn completely on their own. They may take advantage of training, but they may not at all, and there's no obligation for them to do that. So there is more detail in there. So we're going to try to replicate the level of detail, and we're going to try and make the changes as minimal as possible. Obviously, with the QLTS, it's slightly tricky because with the QLTS there is an MCT coming up in July, which will obviously be on the old rules. The MCT coming up in January 2020 will be on the new rules. The OSCE in November 2019 will be on the old rules. So we have to be a little bit careful about how that information is all put out there, because it's going to have to, in the short term, stand side by side so that people have got the relevant day one outcomes for them. So we will do that though.
Yeah. There was a hand at the back, yeah?
Yes, I was just thinking ahead. We have full-time and part-time cohorts, as a lot of institutions do, and we've taken the decision to roll this out next year to give ourselves time
Yeah.
to allow all the guidance, etc., to be available. I'm thinking, I'm accounts, but I'm thinking from the perspective of the part-time students that will be involved in professional conduct. That it comes up in all of their electives and all of their subjects which they will do in year 2, and it would seem unfair that they would then have to learn something new partway through the course, but it would be difficult for us as an institution to roll out the new set of rules for this September, to roll out our materials for them based on the new set of rules this September, and still do it differently for full-time students. There's not some flexibility where, provided we educate them on the changes, we can still assess them throughout all of their elective subjects based on the old rules. Sorry, do you mean your current year 2? No, I mean those who are starting as first year part-time students in September, who would be taught conduct as part of their foundation, but then the rules that they have learned, they'll be assessed on through other subjects throughout their year 3.
I think there is, from our point of view as a regulator, there would be a difficulty in people coming out into practice, or potentially into practice, or into training contracts or whatever they're doing, sort of 2 years down, or well, a year and a half down the line after the new rules have come in, with having been, you know, taught entirely on the basis of the old rules, with just something to update them right at the end. I think I know it's a difficulty whatever you do, and sooner or later you've got to bite the bullet, but I think it's just that our regulatory position would be we're certainly happy for there to be flexibility up to courses starting in September 2020, but then obviously we would like people to move across as soon as they possibly can.
So I have to say I agree with that entirely, yes. I mean, and in fact I think it's, although they will have to learn a new approach, it's not as if this is completely starting from scratch and it's saying all of a sudden, you know, there's no such thing as confidentiality or conflict of interest. You know, the basic things that you are likely to be picking up with them when they are having being taught their electives are likely to be pretty similar to what they've been taught in their first year. Yeah.
Is there a date for your instalments? Deadline you're working towards?
We are. I mean, we're working on them literally, sort of this,
Now.
you know, this week and last week, and obviously we've been looking at them before as well. We would have liked to have got them out for you today, but I think it's one of those things where every time we look at them, we see something else. So. I think the LPC professional conduct and solicitors' accounts outcomes are relatively straightforward. There's a little bit more for us to do on the QLTS, but we would like to get them both out at the same time. Ideally, we would have liked to have had them for you today, but I think we don't want to rush them. We'd rather get them right.
Yes.
In
Yeah.
terms of the August break,
It's good.
Okay, thank you.
So we've now got to 12:30, so I think that's time for lunch. So I'm sure you have other questions, and that's fine. We've got time this afternoon to pick those up. I probably won't be here for the whole of the afternoon session, but so if there's anything particular you want to ask me, then perhaps grab me over lunch. And I think lunches should be available outside the room. Yeah. Thank you very much, and thank you to Carol and Amanda.
that on? It's on.
Yeah.
Is that everyone back in? We're all back in. Good afternoon. I hope you've had a really good to Tinder Law. I'm a policy associate in the Regulatory Education, working with one of the investigations on the new accounts rules. So we thought we'd keep the best till last, because what you've had this morning is probably everything's normal. It's just a bit more exciting. So we'll go through the key changes in terms of what the accounts rules are here to do, what they're doing, and how firms might be using them going forward as well. So if there are any questions, please ask as we go through, because it might just help some of the discussion. If not, just keep the tools easier for the recording as well, those that are watching on a live stream. So the new accounts rules, should we say a little bit different to what we've done, because accounts rules back in October, technically phase 3 accounts rules. Initially done in 2014, we're focusing on the accountants report and who actually submitted to us. What we were getting was unqualified reports being submitted to us. So that's where reporting accountants have gone into a firm and not identified any issues to do with client money. Prompted to by Matt for some reason. So
if I could just swap the mic across, it looks like it's dying.
I'm swapping mics. I'll give you that.
Thank you. Cheers, it's already on. Thank you. Sorry about that.
Back in. So phase 1 was about making sure that we only receive information that was relevant to us. So we stopped the need for firms to submit unqualified reports. And it was also introducing an exemption for firms that were only holding money received from aid agency to get a report. Probably not relevant for you as such, but something that might be relevant in terms of course structure and course content is that the legal aid agency substantially changed the way with firms, especially in criminal cases, and they did their civil change in 2016. But what they confirmed to us was that all the money that they sent to firms was the firm's money. Payments that were due to individual clients were sent directly to the client by way of the systems that they'd now introduced. So it was introducing an exemption again to say that that firms are only holding legal aid money, which is technically their money, wouldn't have to get a report from their reporting accountants. In November 2015, we introduced what was phase 2 to the accounts rules review, which was to focus on what we wanted from the reporting accountants. So it was changing the should we say, checklist approach that we'd got with them, for them to start exercising their professional judgment in how they were identifying not just breaches of the account, but also where they thought there was a risk to client money. So there might not have been a breach, but just in terms of how the firm was managing their money, the money that they received from clients, were the systems and controls that they'd place effective enough to make sure there was never a breach of the accounts rules or a misuse of client money. So that was the focus there. And we introduced an exemption around extending the exemption, should we say, in terms of who actually needed to get a report as well from the accountants. So if a firm was holding no more than 50,000 in the accounting period, or no more than at each reconciliation stage, then they didn't need to get a report. Okay, closer to you. Okay. Feels a bit weird because I'm talking to that and to you as well, so sorry if I'm a bit jilted. So yeah, it was making sure that the extension, well, the appropriateness in terms of who actually needed to get reports was based on the risk that we were seeing. So that exemption came through in November 2015, and we've seen some good results. One of the criticisms that we faced in consultation was that we'd receive less information from the reporting accountants, because they were so used to having the checklist in front of them that now we might miss things that ordinarily would have been in the list. That's proven to be the other way. We're actually getting some really good information from the reporting accountants now, and especially because it's not just focusing on breaches, it's actually focusing on where there might be a risk to client money, that those issues are now coming through to us. And when you look at the ratio of reports that we now get in and the subsequent investigations that take place, again, there's been more of a shift in the fact that we are taking more into investigations based on the reports that we're getting through. So we've had positive effects, should we say, in terms of where we are with the changes that have already been made. Phase 3 of the accounts rules, which is what you've got in front of you, the new accounts rules, was the phase, should we say, it's phase 3, it's the last phase, and it was the fundamental review of the accounts rules. As part of the whole suite of looking at our code of conduct and everything else in terms of what is now the standards and regulations. We focused on, and it's quite clear from the slides, that what we're doing, as with all the other rules, it's making sure that we have a clear framework in terms of how client money must be managed, but going through what is now a principle approach rather than having prescriptive rules, which might work for one firm but not for another firm. So it's sort of moving away from the concept that one size fits all. This is about introducing flexibility depending on whether you're a small firm, a large firm, or you handle different types of money for different transactions. It's up to the firm to understand what's important to them. And I don't think we're moving away. This is something that I think Carol and I do want to make quite clear in the message that we deliver, in the sense that the principle of the current accounts rules is to make sure that client money is kept safe, so it's providing that framework. And the key message with the new accounts rules is exactly the same, that we expect firms to manage client money in a way that it's kept safe, that there is no risk to client money of it misused or being used for another purpose. We think that the new rules are easier to follow and easier to understand. I think one thing that we have to appreciate, and this is where a lot of you will have influences in terms of new recruits or new startups, that, you know, a lot of the new LPC graduates will at some point think about, okay, do we go into a firm and stay there for 5, 6, 7 years, or after our 3 years do we think about setting up ourselves as sole practitioners or small firms? The new rules, what we think that they do is make it easier to understand in terms of what's expected, what is client money, what's expected in terms of how that should be managed, and what sort of records and systems firms need to have in place. So it's much easier for even new entrants to understand what's expected of them as they're moving into the legal market. And what we've done now is, post-consultation, come up with a revised definition or a new definition of client money, different to what we proposed in our consultation. This is, again, probably one of the best consultations that I've worked on. I've been here now 16 years. And sometimes it does feel like we're making decisions pre-consultation, so we just put out what our view is, whereas this is where we did listen to feedback based on what people were telling us. We had a consultation definition which would have really impacted on firms because it was asking them to move money for their fees and disbursements into the business account even before they'd submitted a bill or other written notification of costs. So potentially ring-fencing what is still client money in a separate account. What we've now got, and we'll come on to what that is now, an exemption rather than what was drafted as originally a rule. So like I said, the new rules, they focus on what's needed of firms in terms of to make money is kept safe. We've reduced some of the prescription. Like I said, they're clear, they're sharper, and they set out the standards that firms need to follow. And like I said, on the exemption, I'll pick up on that as we go through. Something that's quite key for us is that the Legal Services Board looked at some research in terms of alternatives to holding client money in firms. They feel that firms that hold client money are more risk, or should we say riskier, than those that don't. So what they looked at was, are there any alternatives? And what they came up with was the concept of barcode that the Bar Standards Board had, which was wouldn't be held in a traditional law firm client account, or should we say a client account as such, but it'd be held in what has come to be known as a TPMA, so it's a third-party managed account. We didn't have any rules as such on these, so firms thought that, yeah, they couldn't adopt this model or go down this route if they wanted to. So what we did to help firms, we issued some guidance in December 2017 just to set out that these are the expectations of firms that are looking to use a TPMA instead of a traditional law firm client account. But we've now codified some of the key principles in the new rules that you'll see as well. Like I said, we'll pick up as well a new approach to final accountants reports, which is something, again, that we focused on, focusing more on the risk that the firm presents to us when they're closing down, as opposed to something that might be 6 months after the event. So the main messages that we're sending out to people is that, yeah, client money needs to be kept safe. That is the key message. I think it can't be clearer than that. But what firms can now do is develop their own systems and controls. I think you had a session this morning on the Code of Conduct for Firms. That sets out the, should we say, the prudential requirements in terms of what we expect firms to be doing in terms of developing their own systems and controls and making sure that they're effective as well, not just sort of having a book in place or an operational manual and then never looking at whether it's effective. So it's making sure that they've developed something that's effective, but it's been applied in the right way as well. So it's the same here, that what we want law firms to be doing is developing their own systems and controls depending on the clientele that they have, but also the areas of work that they're involved in. You know, some areas of work have always been more risky. Like I said, conveyancing, for example, is always seemed to be more riskier than, should we say, welfare advice, because you're not receiving the same levels or quantity of client money. What we've introduced, and this is something I assume that you'll be wanting to ask questions on, is why we've reduced or removed the prescription around the movement of money. So there's no longer any prescriptive timescales that client money, should we say, has to be moved from a business account or the law firm's account into client account within 48 hours, 2 days, or vice versa, where we've prescribed at the moment that any office money or the firm's money has to be moved within 14 days if it's sitting in the client account. What we're saying is that firms have to now move money promptly. This will be a case-by-case assessment that firms have to make. An example that we saw quite recently from our client protection colleagues was where a firm had sat on money. It wasn't an unnecessary delay, but there was a delay. They were dealing with a clinical negligence client, and what they'd had, the client needed access to care immediately, but they needed to pay for it as well before they could get access to the services. But the firm said, oh, we've got, you know, a couple of days, i.e. the 48 hours to move the money. But no, the client needed it there and then. So again, the justification around promptly needs to be on a case-by-case assessment. But the same with the concept of not having to prescribe that firms move their money within 14 days of its, you know, hitting an account, is again, it's up to the firms to understand themselves what, you know, how quickly do they need to move money into their account so that they can then assess whether or not they're financially viable as a firm, but also to pay costs that they're responsible for as a firm, so their own rent, salaries, etc. One of the worries that we do have, and I think this is where it will come through, the question that I often get asked is that what if a firm sits on client money for, should we say, 90 days or 180 days, so yeah, you know, 3 months, 6 months. And I think that's where the code of conduct needs to actually come into play, because it is against the effectiveness of the systems and controls that the firm have in place, but also the requirement on the firm to ensure that they're monitoring their financial viability. One of the concerns that we hear is that law firms will often keep client money, or should we say, no, their business money in a client account because it receives a better rate of interest. And as soon as it moves into the business account, that there are then, should we say, the creditors knocking on the door, or the banks then pull the overdraft facility because now the accounts have become furnished with enough money to carry on. So this is again something that we can now challenge firms on, to say that, yeah, if you've unnecessarily kept office money in a client account because, yeah, the only reason is that you can survive off the interest, but not actually managing your or monitoring your financial viability as a firm, it's something that we can use quite carefully and ask firms to provide a response on. And I think this is where previously the accounts rules and the code of conduct haven't really sat well together. So they're seen as two distinct products that we've produced, whereas now they need to be read in conjunction with each other: the code of conduct for individuals and firms, and then the accounts rules. I don't know whether you saw this morning, but one of the key fundamental requirements in the Code of Conduct for individuals, it says that you have to safeguard any money that's been entrusted to you. So it's not even client money anymore, it's, you know, any money that's been entrusted to you. And again, just allowing firms to exercise their own professional judgment in terms of, you know, what's right and what's wrong. When you look at the reason for the accounts rules, like I said, it's about making sure that client money is kept safe. When you look at the flip side in terms of the claims that then we receive on the compensation fund, the majority are still for dishonesty, so client money being stolen. We could never write a rule which says thou shalt not steal. It just makes no sense. You know, practitioners, lawyers should know that they should not be stealing client money, but that is still the biggest risk that we're facing. So the definition of client money, like I said, this is probably the most controversial of proposals that we put forward in the consultation, but where we've ended up now, it's a clear definition of client money. If you look at in the pack that you've got, at Rule 2.1, we have a section that quite clearly states that it's money that you hold or receive relating to the regulated services delivered by you to a client. Any money that you receive in acting as agent, stakeholder, or where you've been appointed in some official capacity, so again, trustees, or through the Court of Protection. And quite clearly, what we've got here, which you'll see in 2.1d, it says any money received for the firm's fees and any unpaid disbursements. You're probably thinking, where's the concept of professional disbursements? We've done away with that. What we're saying now, it's disbursements. But it's disbursements, i.e. it's disbursements which the client's responsible for. So it's money that they have to pay, for instance, on a conveyancing transaction for stamp duty. Conversely, it's the other side where it's disbursements for which the firm are responsible for. So whether it's payments for experts that they've instructed on behalf of the client, or where the firm is then responsible for something else that they're doing on behalf of the client. But what we've introduced, as I mentioned, instead of having it as a rule as was consulted on, is introduced an exemption. So firms that only hold or receive money for their fees and disbursements which they're responsible for can hold this money outside of the traditional client account. They can hold it in their business account. But this is an exemption which is not on a case by case, but it's the firm's business model. So if at any point in time they start off with this as their business model, so they're saying that, yeah, we only hold money for fees and disbursements, nothing else, and then they get a client where they're acting and they say, oh, okay, we now need to hold some transactional money for you, so whether it's client's damages in a PI case, or completion money in a conveyancing transaction, they'll need to move out of the exemption and regularise themselves through operating a normal client account, as is the case now. So the exemption isn't a case by case, it's an exemption in terms of your business model, so the firm's business model. And like we said, that all other money, if you receive money during the course of a transaction, you'll need to then move into what is now the normal space, which is, yeah, you need to operate a client account. And any money that you held under the exemption needs to then be moved back into the normal client account, because it is still money that's defined as client money, so money for fees and unpaid disbursements. Can I just check I'm not going too fast for you, am I? Is that okay? Thank you. What we have done, because this is a new concept for firms as well, that in terms of understanding what does it mean to operate under the exemption, what does it mean if I then receive money during the course of a transaction, that means I need to operate a client account, but also what do I need to tell my client? It's quite important that clients actually tell firms tell clients what's expected and how their money will be held, because like I said, technically it still is client money as defined in the accounts rules. So clients need to understand that, yeah, money that they've given a firm which is for fees and disbursements, they need to understand the protections, what it means if it's sitting in a business account, i.e. that the firm have got access to it. So the risks around all of that, the client needs to understand what it actually means. In terms of the sort of firms, though, that might take up the exemption, it's still, what we've seen is probably some of the more corporate, commercial sort of firms that are going to be doing this. Because, yeah, they receive very little transactional money, i.e. that it's money that the corporate clients are more likely going to pass between themselves, and then the firm are just dealing with the fees and disbursements. So it's probably the bigger firms or even the multidisciplinary practices that are out there that are going to be looking at this exemption. But it might work for some of the smaller firms that are not doing transactional work either. So if you're not involved in, should we say, conveyancing or personal injury, but you're involved in, should we say, social welfare advice as an example, or housing advice, you're very rarely going to receive transactional money, because it'll be money that will go directly to the client. Same with the legal aid agency side of things, that, you know, that this is where firms probably think of using the exemption rather than operating a client account. Again, with the client account comes costs. It's not just the risk of operating a client, but it's the cost as well. So firms that operate under the exemption won't be subject to the need to reconcile their accounts, but they'll need to keep ledgers and accurate records, but there isn't the requirement to carry out reconciliations because it's their business account. And they won't be subject to having the annual and reporting accountant check that comes in, so there won't be an annual reporting accountant coming in to make sure that money's kept safe. It'll be up to the firm to understand and make sure that what they're doing is compliant with the rules. And like I said, the key here is the actual requirement in the code of conduct, which is that, yeah, you safeguard money that's been entrusted to you, because it is still money that's been entrusted to the individual solicitor or firm. Have a look at the guidance. If you've got any questions after today, please just send it through. But the guidance is in the form of a Q&A. It's not really traditional guidance as such, because this is a new concept, so we've developed it as Q&As. This is a key risk for us as well in terms of client money has to be kept safe. This is where we normally see the sort of teaming and lading examples, or Peter to pay Paul. And this is something that the rules make it quite clear that, yeah, you should only be using... Sorry, it's the examples where we see Peter to pay Paul, or the teaming and lading. So this is where we're saying quite clearly that all money must be kept safe, again, separate from the firm's money. So even though we're not having the concept of what is at the moment the office account in the current rules, we don't have that at all. We don't mention, we just say the firm's money or the business account, but it does need to be kept safe. But also what we're saying as well, like I said, that we've moved out the requirements around moving money within either 48 hours or 14 days. It's to do something promptly. If I was an effective firm, I'd like to see myself moving client money promptly, i.e. probably as soon as I receive it, especially in the digital age that we live in. A majority of firms still operate, well, there's only a few firms I think that operate cheques or checkbook or receive money by cash. If I was receiving money by cash, I'd be a bit worried. But it's online banking, so they receive payments online and they can access accounts fairly quickly. But what this does do is help some of the smaller firms that are out there that don't have access to banking facilities, either because of internet's really rubbish, or the fact that they still operate by going into their bank and posting checks in as and when they receive them. But this just means that they can do something that means that, yeah, they've got their own effective systems and controls in place, and they're satisfied that client money isn't going to be put at risk, i.e. that, yeah, if a check's sitting in their drawer for 3 days, that still there isn't no risk to the client as such, because they're making sure the client is still having access to services. If on the other hand, though, that they are sitting on money, like I said, like I gave the example of the personal injury client or the clinical negligence client that needed money straight away to provide for services, then that's where you'd expect firms to be really looking at their systems and controls to say that, okay, if we receive money in this scenario, what will we do, and how do we make sure that we move it as soon as we receive it? What is promptly? We did ask a question in the consultation that should we issue guidance, and we probably, if we did define what promptly was or issue guidance, we'd probably have about 300-400, maybe 1,000 different examples, because you can't define or provide guidance promptly for every single circumstance or scenario that might be out there. And the worry then is that, as we saw with the indicative behaviour, sometimes, like as we've got in the Code of Conduct at the moment, is that people become fixated with that and think that is the only way that they can manage or operate client money. So this is where it is a little bit different. It's putting the onus back on the firm or the individuals to say, okay, based on what we've got, we think this is promptly. And I think when we go out, if we receive reports or we receive concerns reported to us, this is where we'd ask the firm to provide some evidence or an audit trail of why they've come to that decision. It shouldn't just be, oh yeah, I felt like it on that day, but the other day I would have done something different. It is making sure that what they do is properly recorded and supported by any evidence, including, which I think is key, the instructions from the client. And a key to keeping client money safe is making sure that money for the firm's costs can only be taken after sending a notification of costs or a bill. Sometimes when I'm out and about, you can imagine that we're out quite a lot in terms of compliance rules, is what is a notification of costs or a bill, and does it have to be a paper? Can it be emailed? Does it have to be a completion statement? Does it have to be an invoice? I think a notification of costs is something that's quite flexible. If I've sent a client an email setting out that these are the costs that I'm due to be paying, or these are the costs that are expected to come in the next few days, I think that's a notification of costs, providing that I've agreed that method of communication with my client. A bill is a bill. How that's delivered will again be up to the firm to decide. If they've agreed that all bills or communication will be via email, then there's no need to send a written bill. So I think this is something that will develop over time as well in terms of how firms develop their own systems and controls to look at, okay, what do they need to do as a business? If you're looking to make sure that you're effective in running your business, you want to keep costs to a minimum. So it might be that, yeah, the notification of costs is moving away from paper, so it is more electronic communication. And I think this is something that's quite key. This is where we do receive a lot of concerns being reported to us, where it's that firms actually sit on money after the matter's actually been dealt with. And what we're saying is that as soon as there is no reason for the firm to be holding on to money, then they need to send that money back to the client promptly. And I think this is where we will probably challenge firms more than we have done in the past, in the sense that, yeah, if they're just sitting on money for no reason, then what is the money doing, or what is the account providing? And I think we'll come on to the next slide, which you're probably thinking, yeah, I can see this is what it's doing. That top bullet, which is that, the client account then becomes a banking facility, nothing else. And this is a massive risk for us. We issued an updated warning notice in August last year, together with, I think there's about 10 case studies on what we saw as a key risk, or where we thought that these were breaches of the accounts rules, where law firms were providing banking facilities. What we're saying is that if there isn't any need for the money to be held, so the legal matter, transaction advice has come to an end, then the law firm shouldn't be holding on to that money. They should be paying it back to the client promptly. The more they stray into that top bracket, which is they're just holding money for no reason, apart from the client's convenience, is then, like I said, territory that we'd be worried about. You've probably already seen, as part of the warning notice that was published last year, well, updated last year, but published, I think it was 2014 originally, wasn't it? It was the case of Fruglers, which is the Portsmouth football club. So the law firm that was involved were happy for their client account to be used as a banking facility for Portsmouth football club whilst they were going into administration. So, the administrators thought, these guys really haven't got any money, but they didn't know that the law firm at the time had significant amounts of money that was due to, well, technically it was the club's money. So again, that's really quite interesting. See, that's probably the most, you're thinking, oh my God, it's not just, the individual clients out there, but it is some of the more corporate clients where this risk happens. Where else are we concerned, especially around things like rent deposits? So where clients are providing advice in terms of private rent tenancy agreements. The government have confirmed that law firms, estate agents, anybody else that's doing this sort of work should be using one of their ISAs. They're not an individual savings account. It is some sort of account that's been specifically set up to provide protection for tenants. So the deposit sits in that account and then it's returned through that facility to the tenant at the end of the agreement. In terms of commercial rent deposits, this is where government haven't provided any facility yet, but what we're saying is that there needs to be a proper need for the client money to be held, or should we say the deposit to be held in the firm's client account. Some of the issues that we get sometimes is where law firms are saying to us that, we're doing it because one of the terms that we've drawn up or included in the tenancy agreement is that we will hold the deposit in the client account, pending, possible dilapidations or a dispute between the landlord and tenant. And we're saying that, well, again, it's one of those situations that you're assuming something will happen. You're assuming there will be dilapidations. You're assuming that there will be a dispute between the landlord and tenant. So again, don't do it for the client's convenience, because where you can, you should be passing that money to the clients and saying, look at your arrangements yourselves, or think about something that you can do, which means that the law firm isn't exposed to the risk of operating a client account as a banking facility. Another risk for us is money that's being lost as a result of cyber attacks. This is where firms' systems and controls aren't effective enough, or where, should we say, the email accounts of clients or other individuals that are involved in a transaction have been manipulated, and the firm then just receive what looks like the client's email, and the money's gone off to somebody else that's got nothing to do with the transaction whatsoever. If you look at the research that we've done around cyber fraud or cyber attacks, you can see that the amount of money that's being lost through these sort of attacks is not decreasing, it's actually going up. I think in 2016, it was 10.7 million had been lost. Last year it got up to 13.4 million, so you can see that it's just growing. And again, that's got nothing to do with the accounts rules as such, because we can't prescribe for that. It's about making sure, though, that firms have got proper systems and controls in place. So again, for you, as practical examples, it's thinking about, okay, if a firm had 500 employees, is it right for all 500 employees to have access to the firm's banking facilities and the passwords that are there? But on the flip side, is it right that only one person has control? So it's again those sort of scenarios that can be played out to say that if it was just one person, what if they get run over by a bus or decide to leave but don't pass on all that information? What happens to the firm and the accounts there? And then on the flip side, if you've got 500 employees in a 500 employee firm, all having access to bank accounts and the client accounts specifically, or if money's just moved and there's no proper systems or controls. So it's finding that fine balance as to what's right for each individual firm. Withdrawals, this is quite key for us. Again, it's making sure that, client money is only withdrawn on client's instructions. It's quite, people shouldn't just be moving money as and whenever they see fit. It's something that's quite clear in the rules. and can only be made for the purposes on which the money is held. So this is the point that I was making about Peter to pay Paul. You can't have money received for Jatinder's conveyancing transaction then to pay for Carol's acquisition of, you know, PwC or, you know, one of the big law schools out there as a corporate entity. So it's making sure that, yeah, if it's received for Jatinder, then it has to be used for Jatinder's matter. And that's where the ledgers are really, really quite important, in the sense that you'll see the money actually coming through, and it will show, yeah, money's been received for Jatinder's matter, because the ledger should still state, and again, it's not something we're prescribing in the current rules. We don't say that the ledger has to show X, Y, and Z, but a good ledger should have at the top Jatinder, client matter for, yeah, acquisition of company or purchase of property, so you know it's that matter. And if you see any dodgy, or if the firm sees any dodgy movement of money, or thinking, okay, why is Carol being paid from Jatinder's account, even though it might be a general account, but you can see just on the account itself that, yeah, that's where firms really need to start asking questions into doing what, where. And firms do need to have proper systems and controls in terms of the withdrawals, again, because they need to be appropriately supervised and appropriately authorised. And this is, I think, where we've seen some, I wouldn't say criticism, but where the coffers in firms, so the compliance officers for finance and administration, are saying that, is it our responsibility to sign everything off, or should it be those that are the senior partners in the firm? I say it depends. You might have a senior partner in the firm that has got nothing to do with the firm's finances in terms of how money's posted out from a day-to-day. You know, they're just there because they're a senior partner. Yeah, it is somebody that's running the practice in terms of the cash book and everything else, so the finance department of a firm that knows what's happening. So it might be that they're the ones that are appropriately supervising the movement of money, because then they can raise with the senior partners or even the coffer to say, look, we've seen some odd movement of money. Can we just make sure that everything is properly in place in terms of have we got the right systems and controls? In terms of appropriately authorised, again, it might not have to be the coffer at all points. It could be somebody that actually deals with the money on a day-to-day basis. There is a risk with that, though, that, you know, again, that if it's just that one person that knows the inside out, sometimes you'll see them, again, moving money suspiciously or in a fraudulent way. And that's where we have seen some of the legal cashiers where we've taken action against them as employees of a firm because they've, yeah, used money in either dishonest way or failed to account to the clients. Something that's quite key as well, this is something that you're probably thinking, where is it in the rules if you're familiar with the rules? The rules at the moment have some guidance or technicalities around how residual client balances need to be dealt with. A lot of firms do see that they're holding residual balances, especially where they've acquired firms that hold balances from previous cases. At the moment, it says that you can only move client money where you've got residual balance. If it's under £500, you need to follow certain principles. So you need to make sure that you've done all the checks that you can ever do, and then you can move that money without the SRA's authorisation. Anything above £500, they have to apply to our profession ethics team to say that, yeah, can we have an authority from you that we can now release this money from the firm's client account? And they have to demonstrate to ethics, just as they do internally in terms of balances £500, they have to demonstrate that they've done what they can do to trace the clients. What we haven't got in the rules now, though, is that level of prescription, because what we've now got is that the money can only be moved on the SRA's authorisation, which is the above 500, or prescribed circumstances. The prescribed circumstances sit outside the accounts rules. There's something that will be published hopefully in the next couple of months. And at the moment it's confirming, or yeah, it is the status quo in terms of any balance under £500 can be withdrawn in the following circumstances. Anything above that you have to apply to ethics. The reason we've moved to prescribed circumstances is that it gives us some flexibility. As and when we see different risks, we can then change those prescribed circumstances without having to change the rules. So it's something that's quite key. One thing that we do want to say in terms of key messages is that prescribed circumstances, or what we go to publish, is not guidance. It shouldn't be confused with guidance. They are prescribed circumstances. So if a firm doesn't do this, it is the same as effectively breaching a rule, because it sets out what firms can and cannot do. Can I just check the temperature in here? Either is it me, because I saw a few people sort of just waving, thinking that we need to get some air. So I'm going to turn this down. If it does get too cold, just shout. Unfortunately, we haven't got windows here. You can imagine why. So yeah, have a look when this comes out. We'll make sure that this comes through you, either through Carol or myself or through Pat. We'll make sure that you get sight of the prescribed circumstances. What you'll also see is that we've confirmed that solicitors working in not-for-profit organisations, so law centres, again, they can hold client money in prescribed circumstances as well. So again, that's just setting out some of the parameters there. Putting things right. So this, I suppose, this is where, a lot of your course content will be, okay, what do students need to know when something goes wrong? What should they be focusing on? Key message is that, any breaches identified need to be corrected promptly. That isn't different to what we have now. It's quite clear that as soon as you see something go wrong, you need to make sure that you sort it out. In terms of whose responsibility is it though, again, it's making sure that if you look at the introduction of the rules in terms of who they apply to authorised bodies, their managers and employees. So it's quite key that, it's not just passing the buck to the coffer in a firm to say, oh yeah, we've identified, it's up to you to sort it out. People need to take responsibility for their own actions, and that's quite key. The key message that's coming through the Code of Conduct as well is that individuals need to take responsibility for their own actions. And I think Carol or Amanda might have covered this morning the obligation on individuals or firms to report concerns to us. And this is quite key that it links into that as well, that if somebody does see something, and they're not sure, that we're not asking them to say, you have to say there's been a breach of the accounts rules, but where you have seen a risk to client money, for individuals to report to us. So that might be something that you develop as part of your course material to say, okay, you're presented with a scenario. Would you as an individual, if this is what you were in a firm, you're an employee of a firm, you see something, be comfortable in reporting conduct or those potential risks to the SRA? But also, how would you then do the following, which is making sure that, the breach is being rectified, so making sure there's proper channels within the firm to escalate concerns, but also that the second bullet point, which is that there's an obligation to immediately replace any money that's through dishonesty, some money that's been stolen, or there's been a failing account, so the money's gone into some other account, so potentially the firm's business account has to be replaced immediately. And this is quite key where the terminology differs slightly, because we've got promptly in terms of breaches being rectified, but any shortfall or withholding of money from the client's account has to be replaced immediately. So there is no scope for saying, oh, we've got a couple of days, or the systems and controls are such that, we've got 7 weeks to sort ourselves out. And like I said, firms really do need to consider their duties to report to us. The earlier they report concerns to us, the earlier we're likely to engage with them and find out what's going on. And key, like I said, just a point to note that, the accounts rules shouldn't be read in isolation. So that's a key message that we want to send out as well in terms of material that you produce, that the accounts rules shouldn't be read in isolation. They need to be read as part of the Code of Conduct for firms especially, and the Code of Conduct for individuals. TPMAs, in short, this is a new concept. We're seeing quite a few firms moving into this space. So again, in terms of course material, it might be something that's quite interesting from an innovation point of view in terms of, okay, if I was setting up a firm, or if you were a student and you were given a scenario, set up your own firm, this is what you might want to do. And if you're looking at risk and exposure, especially in relation to not just the risk of client money going missing, but the impact that it has then on the firm's reputation, but also things like professional indemnity insurance, because a claim on a breach of the accounts rules is automatically a claim on the firm's insurance. So if they're not holding client money because they're using a TPMA, then that risk has moved away quite significantly. So this is where it will be quite interesting in terms of how some of the new startups start thinking about, okay, what can we do? Like I said, there's nothing in our current rules that prohibit the use of TPMAs, but what we've done in the new rules is just set out some parameters in terms of, okay, if you are going to be using as a firm a TPMA, you need to make sure that it's someone that's authorised and regulated by the FCA and is part of the payment services regulations or has signed up to the voluntary code of conduct that's there. It's making sure that the clients actually agree to this. It's not just saying that, we're going to do this. It might be the firm's business model, but the clients actually have to agree. You're probably thinking, why? Reason being, it's a two-way authentication in terms of the movement of money, which is why it becomes a third-party managed account. So you have Jatinder Loyal as the payment services provider. Money's deposited for the client. So you have Carol and Pat as Carol as the client, Pat as the firm. Pat says that, okay, we need to move money for a conveyancing transaction, so I need to move sale proceeds or mortgage monies onto the party up the chain. Carol will get a notification to say, hi, Pat's trying to move your money to such and such, can you confirm? Carol will have to confirm as part of the authentication process that she's happy for that money to be moved. So it's quite key in terms of consumer protection, I think, because yeah, as a client, you're now more in control of the movement of money. You know, it's not just a call for them to say, hi, we're going to be completing tomorrow, so we're going to be moving X, Y, and Z amounts of money. The client actually knows. We thought as well that this might be some of the more commercial or the bigger firms that would move to this, but no, like I said, some of the feedback has been that it's some of the smaller firms out there. And especially where they're looking at innovative ways to deliver services, and especially where they've got clients that are pushing them for more information in terms of how their matter's going to be handled and processed. So it is a little bit different. Key messages that we want to say, though, is that we don't regulate the firm in terms of the TPMA provider. They're FCA regulated, and we have a really good relationship with the FCA in terms of sharing information. So if we have concerns about a TPMA provider, we will report that to them. But on the flip side, they will report anything that they see suspicious as well. So if the TPMA is being used for something that's undesirable, then they're likely to refer that to us. But there is guidance, and like I said, we have updated it as well now as part of the new standards and regulations. So even though it was guidance that was published in December 17, it's been updated to reflect just some of the behaviours and standards of the new code of conduct as well, because again, primarily it's about what information is given to the clients when they agree for it is their money to be held in a TPMA as opposed to a traditional client account. Systems and controls, and I suppose this is again where some of your course material might be focused on in terms of, okay, what does good look like in terms of record keeping? We're saying that these are three key, I think, questions. The records need to be, so it's all records to do with client money, need to be accurate, contemporaneous and chronological. And that's quite key in terms of the chronological records, in the sense that they need to show the accurate movement of money as the money is received or then paid out. So in terms of the ledger should show, money's come in, money's gone out, money's come in, money's gone out. There is no difference in the new rules in terms of how firms keep ledgers in accordance with the current rules. So in terms of how they record transactions, it isn't going to change. Like I said, firms are still required to keep ledgers. One thing that's quite key, though, is that we're asking firms to keep or obtain at least monthly or at least every 5-week statements, and then carry out 5-week reconciliations. So they will be keeping balances, they will be keeping a cash book balance, they will have their ledger and showing the transactions, so they can do their 3-way reconciliation. So how you teach 3-way reconciliations now is going to be the same going forward as well. There should not be any difference in that material. One thing that's new, though, that isn't in the current rules, is that we're imposing an obligation on firms to keep records and carry out reconciliations in relation to joint accounts. So where they are signatory on joint accounts or the client's own account, it's quite key, because some of the risks that we're seeing, again, that this technically, even though it's not client money as defined, it is still the client's money. So there needs to be some checks and controls there. Where you probably see those sort of examples is, say, for instance, you're holding joint accounts with another firm. So there's 2 firms that are involved in acting for the client. It might be on a matrimonial case where you've got the husband and wife separately represented, but there's a joint account in terms of the movement of money, in terms of whether it's a matrimonial conveyancing or just settlement at the end of a case. On the client's own account, this is where law firms are, or should we say the individual solicitors, are named as power of attorneys on a POA or lasting power of attorney, or they're appointed as trustees in a trust, so they've got access to the client's own account. The money's not actually sitting in the law firm's client itself. Just to point out, though, that on the client's own account, we have recent feedback, which is that just the way these accounts operate, it might not be possible to obtain statements every 5 weeks, just because if they're ISAs, say for instance, or they're mature accounts or personal equity plans, they only provide annual or 6 monthly statements. So that's something that we're looking at to see whether, we know there is a risk, because we've seen those cases come to the compensation fund where solicitors have used the client's own money to finance their own personal lifestyle. So we know that there is a risk there. We just need to look at whether what we've actually introduced, is it the right way? So that's something that we're just working on at the moment. But there is guidance, and I think this is really, really quite key. This was guidance that was published with the help of our colleagues in our forensic investigations team. It is, should we say, top tips in terms of helping you keep not just good records but accurate records as well. And some of the terminology, a lot of firms, especially the new startups, struggle with the terminology. You know, some of them are like, you know, okay, what is a reconciliation? What is two-way bookkeeping? What does netting off mean? And things like that. So it's language, so the guidance is there to help them, especially new startups. Though even those firms that only start holding client money now, they might have been practicing for, you know, 20, 30 years, but because the areas of work are now that they're involved in mean that they need to hold client money, you know, it's the first time they've ever been exposed to the risks and especially what they need to be doing in terms of controls and records. But that is guidance that has been published. Have a look at it and hopefully it's of use to you as you develop your material. Not too long to go, so I'm not here for much longer. And yeah, it's like I said, it's more about the risks and making sure that the client money is kept safe. And as part of managing that and making sure that what else can be done by a firm, it's the role of the reporting accountant, really quite key. Secondary check. It's not us going in, it is a separate independent firm of accountants that are going in to make sure that client money is being kept safe. There is no risk to client money being misused. And like I said, it's there. Okay, there is the exemption. We introduced the exemption because we felt that, yeah, the risk can be tolerated at those levels, but any firm that's, say, holding money, whether it's more than 250,000, will be subject to this check. And it is about helping firms make sure that money isn't at risk. But what the reporting accountant then does, especially with the rules that were changed in November 2015, so like I said, this isn't a change that's happening now, it's already happened, is making sure that the accountants, when they go in, is that they do the checks that they think are sufficient and necessary depending on the size of the firm, the amount of money that's being held, the sort of clients that they serve, but also thinking about, okay, what has their previous history been like as well? Have they had no issues, so they've always been compliant? Or is it that now they've had some new rules that have slightly changed the culture of the firm, which means that we need to do a few more checks that we probably didn't do before? Again, it's making sure that the accountants think about the work that they're doing. So like I said, the focus that we pushed through in 2020, we're saying that the accountants as professionals should be exercising their professional judgment in establishing whether or not, like I said, it's not just a breach because that becomes very, yeah, tick the box and off you go. It's that, yeah, is there a risk to client money? Are the firm operating in a way which means that client money is at risk? And with the changes that were made in 2015 and now following through, there is less prescription in terms of what the reporting accountants are having to do. It's about them making sure that what they've done is satisfactory in terms of, yeah, they've given the firm technically a clean bill of health by saying that, yeah, there are no issues. What we're saying in terms of how firms engage with their accountants, though, it's going to be on terms that they agree with the accountants themselves. At the moment, we've got an appendix which is quite detailed, quite inflexible, because what it doesn't do is take into account some of the newer risks that are coming through. And this is where the new rules are quite helpful because we can prescribe certain terms as and when we see fit. So if we're seeing an increase in law firms using their client account as a banking facility, we can say to the accountants, yeah, you need to focus on those areas, that risk. Or if we're seeing more firms being subject to cyber attacks, it might say, can you just look at the firm's systems and controls in terms of how they manage and respond to cyber attacks? So the focus can be quite different depending on what we're doing. And like I said, we've issued some guidance. This was guidance that was published in 2015, but has now been updated again significantly as part of the new accounts rules, just to highlight some of the changes in the language around. Did have prescriptive timescales, but now looking at promptly. But also just making sure that the accountants know that this is about them exercising their professional judgment. But what it does do is sets out, okay, this is the good. These are the sort of the good behaviours that, you know, or the good examples of where systems and controls are doing what they need to do. But this is where the bad is. So yeah, this is what we're really worried about in terms of no system controls or they're there just for ticking a box rather than being effective and applied across the firm. And finally, I think, this is final reports. This is where a firm closes. So the changes that we've introduced, at the moment, the rules say that law firms, when they're closing or cease to be an authorised body or cease to operate a client account, have to submit a report within 6 months of that date. And we're thinking, okay, so they've got 6 months out and then get a report, okay, but what if we're really concerned at that point in time and we need that independent check through the accountants? This is where it's quite key, because what we've done is change that we get from firms when they're closing or ceasing to operate as an authorised firm. So we're asking for now real-time information. We're asking for bank statements and reconciliations to be provided at that point in time. I think then that there is a concern that's not being validated by the information that's been provided by the firm. We can say to the firms when the rules come in that, yeah, you've got 2 months to go and get a report and then a month to. So it's up to us when we think a report's due. It's not going to be an automatic, which is quite costly as well. When you look at the cost of getting an accountant's report, think at the moment, accountants charging between £6,000 to £8,000 for a final report. So it is quite costly on firms as well. But if firms are doing everything they need to do in terms of winding their practice down in an orderly, good way, then the need for a final report is probably not likely or needed. But factors that we probably take into account are things like, when we get information from the firm on closure, if there's inconsistencies in the bank records that they've provided, open conduct matters, or even previous poor compliance. So if we've seen a raft or a history of qualified reports from the accountants, we just want to make sure that, at the end, everything is intact. And that's me and the accounts rules. Questions? Hi.
So, under 4.1, for example, we've got a distinction between client money and money belonging to the authorised body. So from a terminology point of view, is it still okay to have ledgers drawn up for the materials with office money and client money?
Yeah. Okay. Yeah. So I think from a ledger point of view, it's quite key. Again, it just shows that, how the firm's operating is effective. So the ledger should still show that, this is now money that's due to the firm because we've issued a bill. So the ledger will just show, the bill's been issued for 400 quid and the money then goes into the firm's account. What we're doing is probably, I think a lot of firms are probably used to saying, okay, here's a descriptive list of what is office money. I don't think we need to do that because the whole purpose of the accounts rules is client money. So it's making sure that we define what is client money. Anything that's not client money then is technically the firm's money.
And just to add that, it's rule A2, isn't it? Recording client ledgers or receipts and payments which are client money and bills, of course, including transactions through the authorised body's account on the business side of the client ledger. And I think partly of this, as Jatinda said, it was because we don't regulate what happens to the firm's own money. What we're interested in is safety and security of client money and making sure there are proper accounts to show that. So that's where it comes in, isn't it?
Have I missed somewhere in the rules where, in previous rules, an advance from a lender was client money?
Yep.
So is that in here somewhere, or that?
So it's still we used to have rules around institutional lenders, and there were separate rules in terms of how that need to be dealt with. But no, what we've done is included that within the definition of client money. So it is client money because the institute or the lender will be the client. So it doesn't differentiate between whether it's a private client or a commercial client or a client. How firms deal with that money is exactly the same.
So you've got, cause the lender will be client one, or whichever way around, lender and client, there's 2 clients.
Yep.
But paying it into the same.
Into the same, yeah.
That's still okay.
That's still, exactly, because you're acting for those clients. So again, we don't see that there need to be 2 separate ledgers. There might be firms that do operate separate ledgers just for accounts purposes, or it might be that that's how they demonstrate that they're fit to be on the lenders panel as well, because how lenders then prescribe is up to them. And a lot of it is through what used to be the CML guidance, which is the Council of Mortgage Lenders guidance, which is now UK Finance. And it's them that sometimes have prescribed in terms of the accounting practices. But for our purposes, a lender is the same as a private client. And if you've got, should we say, the sale of my address, number 3, whatever it is, that it's money coming in, so it's money being received for that client, for that client's purposes.
How does that apply to stakeholders with a deposit, for instance?
Very much the same. So again, the rules clearly state that client money still includes stakeholder money or agent money. So again, if it's been received by somebody else as part of the transaction, it can be recorded in that same ledger. There isn't any change. There isn't any change. As long as it's properly, and I think this is where Rule 8 is quite clear. Or should we say that what we're hoping to achieve is that the records need to be clear, contemporaneous and chronological. So it's making sure that it's clearly identified where the money's coming from and then where it's going. And again, I think this is part of the, as you develop material, it's looking at, okay, if you're receiving money from X, Y and Z that's got nothing to do with the client's matter, then again, you potentially other firms falling into the banking facility area, because they are now receiving money from somebody, well, might be related to the client, but for what reason? Hi.
Sorry, just a couple of quick questions, if that's all right. First one, correct me if I'm wrong, but so is there a rule that with mixed money, you can pay it into an office account as long as the client money is taken out? Because there used to be some restrictions about, obviously there was the fallback rule that regardless of its composition, money could be paid to clients.
So
on my reading of it, that you could pay mixed money, it says more that there's this idea of mixed money still, and that you just must talk about properly putting money where it should be.
yeah, so the question was that, yeah, if you've received mixed monies, what do you do with it? At the moment, there is restrictive, or the Rule 17 sets out that, yeah, this is what you need to do. If it's office money that's received into client account, you must understand the composition and move it within 14 days. Or if it's client money that's received into the business account, it needs to be moved within 48 hours. So what we're saying now is that it's moved promptly. So again, because we don't regulate the office account, for us, what we're concerned about, so if it does come into the business account for whatever reason, it needs to be moved out of that account promptly. And I think this is where firms really need to understand the risks. And I think, as new recruits or those that are being taught, it's understanding the risks around money being held in an account that's outside the client account. So in an insolvency situation, if the money was being held in a business account, creditors would have access to that straight away, whereas the fact that it's sitting in a client account means that the insolvency practitioners or the creditors can't touch it. It is separately regulated through not just our rules but through statute as well. So I think it's quite key in that sense, which is why what we're worried about is that, yeah, firms, as they develop their systems and controls, need to show that, yeah, as soon as they have money come into the business account, which is client money, there should be some sort of alert to say, yeah, move this promptly.
Sorry, the related question was with this written, you mentioned about the written notification of costs as opposed to a bill. And what we used to say to our students was, it's always sensible to wait, because when we were doing a ledger question, we would say, we'd then ask you to transfer the money over to office. So I'd always say to them, it's sensible for you to wait, but there are certain circumstances where you can transfer money over to office where you haven't sent out a bill or written notification of costs. Am I right in thinking that that's changed now, obviously, and the follow-up to that point is, you mentioned about the flexibility of what that written notification would be. It could be an email. Am I right in thinking it should still specify that exact amount? So it can't just be an email saying, we expect to be incurring this range of costs, for example, that you might send out at the start. Is no, you've got to send something to say, we're going to be incurring this. There might be a position yet where we paid for it, we've not yet claimed it back from you, and we can take it out of client money.
Yeah, so the question there is about, okay, what do we do where you've got the circumstance, instead of having a bill at the very end or the completion statement say, this is money that's due to you, this is money that's due to me, it's that, okay, during the course of the transaction, is there a need for money to be withdrawn prior to that final bill? And the question is, yeah, it will happen. So say, for instance, you're instructing counsel and counsel is saying that, yeah, we can't start work on this until we're actually paid. And that might be because of the arrangement between the firm and counsel themselves, because there's been some history of bad payment or delayed payment. So the counsel might be saying, okay, the only way I'm going to work for you and your client is that, yeah, you make sure that I'm paid now rather than having to wait until 2 or 3 years after the event. So those, again, it will be the notification of costs. So counsel will say, these are my fees, this is what's due to me, or this is how much it's going to cost, and then you tell the client that, yeah, this is how much counsel. And it does have to be specific. And I think we do say in the rules as well that it has to be, you know, it's for that amount, you know, it has, the notification should be for the amount, yeah.
It used to be slightly different with the disperse, because obviously I know you make not got a distinction anymore about professional disbursements and other disbursements. There used to be this limited ability, although it was sensible to us about the client. You can move money out of client account without that specific bill going out first or other written notifications. So it's really from an exam point of view that we put earlier on in the ledger questions. You send out, you have sent out a written notification of costs, and us specifying to students, always wait for the easiest way I think is always wait for the instruction and the narrative.
Exactly, and I think it's 4.3c, which says that any such payment must be for the specific sum identified in the bill of costs or other written notification of cost incurred and covered by the amount held for the particular client. So this is, I think for the exam questions, I think one thing that could be developed further is that, making sure that the client account isn't overdrawn. Because then, if you're saying that, you've got council that's expecting £2,000 of fees to be paid now because, they've done some work and the costs have been incurred, but the money in the client account is only £500, you can't make that payment. So again, it's not using Peter to pay Paul, those sort of examples that, just because Paul's account is nicely flourished with, 5 million, just use a bit of that until Jatinder coughs up and deposits money into his account. So I think it's quite useful as part of the exam questions just to say that, wait until you've received the confirmation that these are the costs that have been incurred, and then inform the client that this money is now going to be moving out from the client account, but also making sure that there's sufficient funds in the client account before the money's been withdrawn. Any more?
Just on that question about terminology, obviously we don't prescribe that anymore, but I think when we do the LPC outcomes and also the day one outcomes for the QLTS, we probably will refer to a business account simply because to avoid any confusion between the current terminology and so business account will be a generic term for an account for the authorised business.
So hopefully that's... Oh, sorry.
Sure. These TPMAs.
Yep.
How does that fit in with the anti-money laundering regime? Because presumably then the clients can just put money into that account if they haven't actually done no money laundering checks on.
So the question there was that, in terms of TPMAs and the use of them, how does it fit in terms of the AML regime? So the requirement to do due diligence doesn't move away. So in terms of the money being received, even though it's been not held in the client's account, the TPMA regulations, what we've got is that its money has to be for that specific purpose, for the regulated services that have been provided. So if I started to receive money or seeing a deposit of money that had got nothing to do with the matter on which I was instructed as a firm, I'd get slightly worried, and I think that's where the firm's AML obligations are then, should we say, come into play, because the money that's been deposited into that account has got nothing to do with those regulated activities. And the same, which if the client then started to say, can you from this TPMA start making withdrawals for X, Y and Z that have again got nothing to do with the transaction itself, that's where the firm's systems and controls and the alarm bell should really start be going off. Because even though the TPMA isn't, or the money that's being held in the TPMA isn't client money, and the TPMA isn't a client account, we'd still be worried if firms were then using that as a vehicle to start, or allowing clients to use that as a way of money laundering. So the AML regulations, that even though it's not just about client money, it's about, what due diligence are you doing on your clients generally?
Would you not expect the TPMA to actually have those kinds of checks in place?
Yeah, so that's what we've been talking to the providers out there as they're developing their systems and controls. What they're doing as well is making sure that the information they get from firms. So again, the question was, what is it that the TPMA providers are doing in terms of checks and balances? And I think this is quite key as they're developing their products. What they don't want to be doing is exposing themselves to the risks of AML. And as they develop their authentication processes, it is something that they're introducing to say, it has to be for a specific matter, which is why it's not just an account that's open-ended. It's opened, or the arrangement's only put in place for that specific matter at that point in time, so it closes as and when the matter comes to an end as well.
It's kind of, following on from that, it's more of a source of funds issue. So if that client's got access to the TPMA, but we haven't yet, or we're not satisfied as to the source of funds, but they're piling money in, when it comes back out, it's already clean, doesn't it? And we haven't got control over that.
Yeah, and I think that's always going to be the case in the sense that, and I think that's where the FCA's regulations, which is why the TPMA providers were saying that have to be FCA authorised, but also the payment services regulations. So as soon as the TPMA providers start seeing an influx of money, but when the arrangement was set up, it was for, should we say, a conveyancing transaction, using that as an example. Then all of a sudden, the conveyancing transaction said, the purchase price is £500,000, and then all of a sudden there's £3-4 million worth of money come in. That's where the TPMA provider will start saying, look, this isn't right. And as they're developing some of the material that they've shared with us, it does show that they are really quite worried about this in terms of, but which is why the terms on which the TPMA is set up are quite key in terms of the law firm and the provider.
Because as MLRO in a firm, and you've got that personal responsibility to check the source of funds. and even if there could be £500,000 in it, but it might be £500,000 from a different source.
Yeah.
And you won't have the control.
Yeah, and I think that's where what we're asking for. If you look at some of the guidance around TPM, not just the guidance, but even the rules are there. It's just making sure that the client even understands the exposure that they potentially could have as a result of this as well. So it isn't just the fact that, because it's no longer in the law firm's client account, so the client account's not being used to clean the money, that if they're using another facility, that the client will still potentially be exposed to, criminal investigation. I think it's one of those areas that we'll see how it grows and how it develops, but the TPMA providers are quite keen to make sure that that their accounts now aren't going to be used as a way of cleaning money. Any more? Sorry.
It was just really a comment to the room just about the exam, because what we're thinking of doing at Sheffield, if we consider anyone else thinks anything, is that because of the reduction in the number of rules, we're thinking, at the moment we assess the exam in 3 parts: ledger question, completion statement, and some short answer questions on the rules. We currently assign 30 marks out of 100 to the short answer questions, because we go through quite a lot of stuff in detail, a lot of stuff about mixed payments, obviously, and various other things that have gone. I don't know if anyone's had a thought about this yet, about whether they're considering keeping the short answer questions and just maybe setting a few of them, if that's what they do, or whether it would be better focusing perhaps on compliance, or maybe more of a focus on a scenario where you ask the students to think about various issues and show some general understanding, or if anyone has any thoughts. Or have they not thought about it yet?
I think from my side, the question there was about that should course material be developed or changed based on the current way that the exams are assessed or that students are assessed. And I think for me that the ledgers, the need to keep accurate records, chronological, and a proper audit trail of how client money has actually been held and received and then passed out as well is quite fundamental. So I think that that if a person doesn't know that, they are at risk that when they do go into practice and they're asked to do something, they're going to lack that knowledge. And like I said, the current rules don't even prescribe what a ledger looks like or anything. It's something that is developed by you and other practitioners out there. In terms of the secondary element about a completion statement, that's again just a practical example. On the third side, I think it should be around, my personal views about the risks, not just about what's the breach, because a breach is a breach. And I think for us, a misuse of client money is so serious that that stuff that the tribunal. But it should be more about that if you're given a scenario, so like I said on the withdrawal, or the council, if council said they want £2,000, but you've only got £500, should you be using, Carol's account or Carol's money to pay Jatinder's costs that you heard on the mat? So it's those sort of examples, those sort of risks, and thinking about that obligation on the employee in the firm to be able to be confident enough to say that we've highlighted something and how should it be rectified promptly.
I think that's a really good suggestion, because we were chatting earlier about the problem with the accounts exam. Certainly Sheffield is, and apparently it's true of other institutions, is that our students leave the short answer questions to the end. Probably don't answer many of them at all, because partly because the other sections are negatively marked, but partly because they're not really learning them in that way. It's a very different skill. They're obsessing, and I mean obsessing, about how they record the ledgers and how they do a completion statement, really hone their skills in that. And they're being very tactical and know they can get up to 70 marks for the other 2 parts of the exam, and then just either not answering any of the short answer questions or not all of them. And I agree with you that it's the compliance stuff and the basic fundamental principles that we're really worried about, and identifying whether they're inadvertently making a mistake
exactly.
or whether they're doing something which is a total breach of the rules.
And I think this is quite interesting that that I had a discussion with Pat as well, that about what sort of, where should the focus be, and as a new recruit into a firm, are you going to be doing ledgers and completion statements, or are you going to be focusing on compliance? And I think it's varied. I remember before I was in policy, I visited a conveyancing factory. All of their new recruits, the majority of their recruits were in the pre-completion team. So they weren't doing any completion statements. They were there responsible for doing the searches and all of that sort of stuff, and making sure that, yeah, the mortgage contracts were in place or the offers were in place. And it was a team of back office staff that were the post-completions team producing just generic completion statements. So they weren't even law graduates. They were just people that had been recruited. So the risk, I think, is quite different. It just depends that, you know, we can't always assume that, yeah, these new recruits or the graduates are going to end up doing ledgers and completion statements, because they might be involved in the very front side of things under the supervision of somebody else, all the pre-contractual or pre-exchange and completion work, and the risks are very different there in terms of where the money's coming from, how it's been handled and how it's been withdrawn from the client account, which is quite different. So the obligation on them, though, there would be to make sure that their file showed a proper note of how the money was being passed, where the instructions had come from, then to inform how the ledger is then completed.
We have talked about this in preparing for today, because obviously when you look at the outcomes themselves, you've got very high level kind of headings, and then you've got two little bits at the end at the moment on the LPC which say, you know, you need to be able to keep accounts and you need to be able to do a completion statement. Obviously, again, we're slightly in the position where we don't want to be making major changes now, because it's just not the right time to be doing that, in a sense, because obviously big changes are coming for all of us and for everyone. So we want to keep things the same. Having said that, we have never prescribed how you weight your paper. So if you felt that you wanted to give more weight to either multiple choice questions or short answer questions on the kind of actual content, and maybe reduce the amount that you're allocating at the moment for solicitors, for the ledgers and for the completion statement, then that's something that you're, you know, perfectly at liberty to do. And obviously it's really difficult, because you're trying to prepare all these trainees to go into practices which are absolutely wildly varying. You know, going in to be a trainee in Clyde & Co, where I noticed on Friday 2 people, including a partner and associate, have been referred to the SRA for breaches of the accounts rules, in the context, I think, of a shipping work. So it happens everywhere, and it happens at all levels, but obviously doing accounts in a firm like that is completely different to going to work perhaps for a sole practitioner, where you're much more likely to be hands-on. I mean, my personal view is that even if you're not going to be making the ledger entries, being able to understand a computerized ledger, as it were, at the end of a matter, which shows not only the disbursements that have been incurred, but also the amount of time that's been spent on the matter, is all about that commercial awareness for students that firms are always banging on about. You know, they're running a business, they need to be able to understand how to charge, and that you don't miss off disbursements because the firm is out of pocket. So I think that still has a value, but obviously if you felt maybe we rebalance our assessment a little bit, then that's absolutely fine, and we would have no problem with that.
Discussing Rule 14.5 and the current rules, there's the backing account facility rules. And we were just interested to know whether actually you do any specific questions in relation to that rule, which for the SRA is a significant risk, and we actually pull up a lot of solicitors for allowing their client account to be used as a banking facility, so in relation to a transaction which they're not providing legal advice. And we see a lot of that, and you know, with the AML, risk very much highlighted, and the case law that we have supporting this, for us is something that we discuss a lot, but I don't know whether it's something that you would specifically have a question on in your courses. So I think you know and you know we've Fuglers, which Jatinder mentioned, was you know the firm allowed, I think, £10 million to go through their client bank account for improperly, and they were fined £50,000 each for allowing it to happen. So it is a very significant risk for us. So I think Pat's right, if you know, without wanting to expect you to reinvent the wheel, and you've got a lot on your plate, but you know, I think if from our perspective, we were looking at this from scratch, we'd be saying concentrate on understanding the basic principles about keeping client, it's not your money, it's client money, it's got to be kept safe and separate. Client bank account's got to be used for the purpose for which it's got to be tended, it's got to be withdrawn properly. All of those things are really the kind of the key message of the accounts rules, which is what we're training you on, not necessarily sort of accounting practice. So there may be something there that you could perhaps take away and think about.
Left field final thought, but is treatment of digital assets going to be on your radar in the future?
It's one of the risks that have been highlighted in terms of the receipt of money through different things. So Bitcoins and e-money. I think it's something that we're going to have to see how firstly people like the FCA respond, and then whether it then falls within the remit of money. I think that from the work that we've done separately on the use of artificial intelligence and delivering services and paying for those services is, it provides opportunity, but with that comes risk. And it's just that where's the tolerance? I think, we're waiting or working with the FCA in terms of, okay, what are they doing? Because they'll regulate the market predominantly. And then how it comes down to us. Bitcoins are especially really, really quite popular at the moment. But in terms of how you pay with Bitcoins and how it's used and whether it actually has any value or not. And it'll be interesting because especially on the use of things like escrow accounts as well, that if you're trading through escrow accounts or FX using Bitcoins. So it is interesting. Unfortunately, the accounts rules don't go into that sort of, weird and wonderful world. I wish it did. Maybe Carol and I in a future life might have some sort of...
We'll be writing it in 10 years' time. There's no money anymore.
There's no money. But no, thank you. Just to say as well that it's not a plug for me as such, but whatever I try and do in terms of the accounts rule, whether it's guidance, whether it's videos, whether it's something I'm doing with Matt, I try and post on LinkedIn. So if you do follow me, I did TPMA videos, for firms and people thinking about doing it. We did a video on banking facilities. So you can pick me up, I think, on LinkedIn somewhere. And it's not just to pick me up, but more about seeing some of the stuff that you might otherwise not see if you don't follow us on social media. So thank you.
I'm conscious that we're just about 5 minutes overrunning. I can definitely stay on at the end until 3 o'clock. So if anybody's got any individual questions, then that's absolutely fine. But equally, I understand that a lot of you are perhaps have travelled quite some distance and need to get back. So if you need to do that, that's fine. Was there just one more question?
It was just very quick. You asked us at the start about when we're planning
Yes.
implementing this. So I teach of conduct and my colleague teaches accounts. If I was to say I want to go ahead and start with the new stuff in September and she said, no, I want to wait, do we have to be, is it all or nothing?
I think we definitely, we've given you the option, but we don't think it would be prudent to have different parts of the course operating different bits. So we think coordination would be better. Okay, so if that's the end of the questions, just to say thank you very much indeed. I really hope you found it helpful. We have tried to get you the people who have been absolutely on the front line. So Carol and Amanda and Jatinder, who've all been involved both in the policy development underlying all of this and also the actual drafting of the new standards and regulations. So we're very grateful for them time for all of you and indeed for myself and Julie to support our regulation and education team. So I'd like to thank them very much and thank you all for coming and for contributing and asking questions and so on. If there is anything at all that we can do in the next few months, we will be following up with an email which will have all the documents that you've been given as hard copies attached and also hopefully giving you some more information as well. So both those of you who've been able to come today and anybody perhaps in your organisation or other organisations who were invited but haven't been able to come. So thank you very much indeed. Thank you.
And like I said, we did say